A heartiest warm good morning to all the dignitaries on the dais. Professor Dr. Balvinder Shukla ma'am, Vice Chancellor, AMT University. Professor Dr. D.K. Bandapadhyay sir, Chairman, AMT Law School, AMT University, Noida. Professor Dr. Shefali Raizada ma'am, under whose leadership and stewardship we are guided into one more chapter. New sun, new beginnings, more knowledge and wisdom, all brought together and culminated into one value-added course directed under the UGC mandate on for Mulya Prabha. Under the theme, Navigating Intellectual Property Rights and Emerging Concepts in Artificial Intelligence. This is an academic ideation, research-oriented, culminating and bringing from the various forums of academic knowledge and industry leadership from various academicians, from various lawyers, from various people engaged with intellectual property rights day in and day out, along with the emerging strands under artificial intelligence and the convergence and distinct incorporating various themes and ideas, international as well as national municipal. I welcome Shailja Khosla, Assistant Professor from AMT Law School, AMT University, Noida, along with my convener, Richa Yadav ma'am, and my co-convener, Ms. Alaknanda Singh. I welcome all the dignitaries on the dais today on this auspicious day, and all the very most dignified eminent speakers, and more than 1,300 registries who have joined today to welcome this on new hopes of having all the knowledge and wisdom on intellectual property rights and artificial intelligence. Like any eventful incidents, we begin by offering from blessings from Goddess of Knowledge and Wisdom. Thank you, Dr. Raghavendra sir. Raghavendra sir is joining us now. From Saraswati Vandana, I offer to Richa ma'am for Saraswati Vandana. Thank you so much.
Om Bhur Swaha Tat Saviturvarenyam Bhargo Devasya Dhimahi Dhiyo Yo Nah Prachodayat Om Bhur Swaha Tat Saviturvarenyam.
A very good morning to all the ladies and gentlemen, distinguished guests, and the participants. Intellectual property is the fuel of the digital age, and artificial intelligence is the engine that drives innovation, as has been said by Tim Cook. With great enthusiasm, I stand before you today at the inaugural ceremony of our workshop, where we embark on a journey of exploring the intricacies of intellectual property rights in the face of the emerging concept of artificial intelligence. This powerful quote from Tim Cook perfectly encapsulates the essence of our gathering today as we delve into the realm of IPR and artificial intelligence. We recognize that intellectual property serves as the cornerstone of innovation in this digital age, and it's the fusion of artificial intelligence with intellectual property that propels us forward, driving unprecedented advancements and shaping the future of various industries. Today, we come together with a shared vision to navigate the integrate landscape of intellectual property rights in the context of artificial intelligence. We understand that the rapid advancement in technology and the integration of AI in diverse sectors have given rise to new challenges and opportunities for protecting, managing, and leveraging intellectual property. The workshop today is not just about theoretical knowledge, but it is an opportunity for us to engage in thought-provoking discussions to explore the legal and ethical challenges posed by artificial intelligence in relation to intellectual property, and to develop effective strategies for managing and protecting intellectual property right in this ever-changing landscape. I would like to extend my heartfelt gratitude to all the dignitaries present on the dais and the participants who have dedicated their time and effort to make these workshops possible. Over to you, Shelter ma'am.
Also, we extend our most deepest welcome and heartiest good morning to Professor Dr. Aditya Tomar, Additional Joint Head and Director, Amity Law School, Amity University, Noida, and Professor Dr. Arvind P. Bhanu. Thank you so much, sir. And as the day unfolds on this wisdom-oriented week and knowledge, we have our first session for this workshop, Dr. Raghavendra sir, for the inaugural session. Dr. Raghavendra requires no introduction. Actually, I don't know what to say. Dr. Raghavendra, I had an opportunity to personally meet Dr. Raghavendra while I was interning in my Delhi Law University Law School days at the Copyright Office. Sir has been the chairman, the stewardship, the directorship, what to say. Sir is a civil servant, has been a civil servant. Sir is behind everything from every nook to corner to the copyright development and the unfolding of copyright, from the knowledge and how the registration of copyright has been done throughout India. Sir has been a pioneer name. And as I said, he is the most seminal authority on copyright and intellectual property rights. Dr. Raghavendra, sir, we, on behalf of Amity Law School, Amity University in Noida, and on the behalf of all the dignitaries, welcome you. Thank you so much, sir, for joining us.
May I request Dr. Shefali Raizada ma'am to address the meeting?
Yeah. Okay. Very good morning to all the dignitaries, our Honorable Vice Chancellor ma'am, Professor Dr. Balvinder Shukla ma'am, Honorable Guest of Honor for the day in the inaugural session, that is Dr. Raghavendra sir, very highly respected Chairman sir, Professor Dr. D.K. Bandyopadhyay, and our all faculty colleagues and all the participants. I convey my heartfelt welcome to all of you on this very important platform, that is the value added course, which we are starting from today up till the 1st July. And which is, we have taken the important aspect that is the navigating the intellectual property rights vis-a-vis enhancing the knowledge on the concept which is emerging, that is artificial intelligence. As we know, Amity Law School always has a very good initiator and has been taking a very important initiatives and efforts to put up the academic and professional inputs in form of the various events and various workshops and the courses. And this course especially, we are going to focus on a very important aspect, that is intellectual property rights vis-a-vis with the interfacing with the artificial intelligence. So I believe in the digital world, in-depth and right knowledge is very important. And it is a high time when we have to go the extra mile, where the IPR and artificial intelligence is going to take place in have a very important role in various domains of our life. It's not only the economy or society and culture, it is going to affect each and every aspect of our human life. So it's very important we need to have not only to enhance or skilling ourselves, but also to have the various mechanism, how to control, how to resolve, how to go into the nitty-gritties and detailing. So this workshop has been planned to focus on these aspects to understand. And this is going to a very important workshop where the students and participants going to enhance their knowledge, to have the awareness, sensitization with regard to the intellectual property rights, how intellectual property rights interfacing with the artificial intelligence. So this kind of the knowledge is very important, and that is why this platform is very, very important as a capacity building program, where the crucial role and crucial aspects, and especially the legal aspects, other aspects are very important to understand. So this is very specialized course which we are starting from today. And on this platform, and from this platform, I welcome, as additional director, I welcome all the dignitaries, all the speakers and the participants. They are there, they have joined, and we are very thankful for everyone to join. And certainly it is going to be a benefited for everyone. So thank you so very much. I special thanks and gratitudes to our Vice Chancellor, ma'am, Honorable Dr. Balvinder Shukla, ma'am. She has accepted our invitation and she is very much there. Certainly her leadership, her innovative ideas in the field, it is in her guidance, under his guidance, we are starting this program and this very important workshop. We are also convey my gratitude to Dr. Raghvendra sir, because this is the first technical session which he is going to handle, and which is very important. And also I convey my thanks to our chairman sir, Dr. D.K. Bandyopadhyay, for all guidance, support, and giving us a good steps and key points how to go for this workshop. So thank you so very much for coming and sparing time for this inaugural session of this very important value-added course. So thank you, everyone. And once again, I welcome you all. Thank you. Over to you, Richa.
Thank you, ma'am. Now I would like to request Professor Dr. Aditya Thomas sir to kindly address the meeting.
Thank you, Richa. Most respected Dr. Raghvendra sir, very good morning to you, sir, and most welcome again to Amity Law School family. As all the times we request you, you just grace the meeting and spare your valuable time to address the students. Now I would like to extend my warm welcome by joining hands with Dr. Shafali Raizada to our Honorable Vice Chancellor, Professor Dr. Balvinder Shukla, Professor Dr. Bandyopadhyay sir, the Chairman of Amity Law Schools, my dear colleagues and the students. As we all know that nowadays everybody is talking about the artificial intelligence, whether it's a GPT-4, whether it's a ChatGPT or any other platforms. Nowadays, some of the countries like us, the India or other countries are trying to explore the possibilities and the artificial intelligence, how we can make the constructive changes in the education, in the industry or so. In some of the developed countries, they ban the use of artificial intelligence in the academic world. So yesterday, me and Dr. Bandyopadhyay sir just joined a function where the renowned speakers told about the same issues, that artificial intelligence and the IPR rights, and they recommend that there is a need of make a balance. So soft approach about the use of AI may not be useful to control the misuse of AI in the industry and in the academics. So by listening the legal luminaries like Raghvendra sir and the esteemed other speakers, we, the academicians and the students, can develop our approach about the use of artificial intelligence in the academics, in the profession, and at the same time, we can protect our rights and respect the rights of others by the way of intellectual property rights. So in the end, without taking much of the time, I just want to welcome to all the esteemed speakers, Honorable VC Madam, and my dear colleagues. Thank you very much. Over to you, Richard.
Thank you, sir, for letting us know the importance of AI and how much discussion is going about AI in the current times. Now, I would like to request Professor Dr. Arvind B. Bhanu, sir, to share a few words of his wisdom.
Thank you, Richa. First of all, I welcome respected Ma'am Vice Chancellor, respected Chairman Sir, and respected Dr. Raghavendra ji on this platform, and my colleagues and the participants for this workshop program. What I'm looking at that AI, artificial intelligence, is a technology, the type of the technology. A technology has been developing since not the very recent time, but it's since a long time. So AI, artificial intelligence. Yesterday, I also joined some program where in Imperial Hotel. I saw that there was a presentation, and in that presentation, one sentence I noted. Sentence was that, okay, AI, artificial intelligence, has entered into the legal domain also. It requires to learn by the practitioner, it requires to learn by the student, by the judges, and every professional in the law. But the key point which I had noted is that artificial intelligence means the entry of artificial intelligence is not going to replace us, the stakeholder in the law domain, but it is going to assist us. And you can see that when artificial intelligence is being used in every aspect of the human life, then law cannot be devoid of. So as a professional, as a teacher, as a student of law, we are to learn artificial intelligence. In the same way, we are to see in a law relating to intellectual property rights. There are certain functional aspects of law relating to intellectual property rights. It also requires the assistance of AI in managing the intellectual property, in enforcing the intellectual property rights, or in enforcing the decision making. So it is seen and evaluated that in every aspect of this functionality, the AI is assisting us. I have seen that because AI now has come to analyze the image, the text, the videos, everything, almost everything, by taking the assistance from artificial intelligence, we can analyze them. You can understand that AI, we are just taking this AI right now with a great enthusiasm. But earlier I have seen that there was a Tarnetin, very common software which came in academic field, in research field, where it was started to detect the similarity index form of the awards. So this Tarnetin software was confined to text analysis and some more analysis of the other side of the research. But this AI is covering a wider scope of this research, like video analyze, image analyze, and text analyze. So I can say this is the advanced form of, in one sense, this is an advanced form of the Tarnetin. So I can understand that the value-added course which is being introduced by the MET is a great effort on the part of the organizer and other supporters. I welcome that on this very point, and certainly it will give learning to the students from the very point, from the initial point, and certainly it will give not only them the knowledge to identify the use of the AI, but also it will provide, this course will provide them the skills, the understanding, every aspect, the understanding to the student for their future profession. With these words, I welcome you all on this the virtual platform, and I wish that it will certainly be a very useful learning to our students. Thank you very much.
Thank you so very much, sir. Now, I would like to request our very dear chairman, sir, to share his words of wisdom.
At the outset, I must congratulate our Honorable Vice Chancellor, Dr. Balvinder Shukla, for visualizing that value-added courses to be provided to the students and the faculty members under the UGC mandate Mulya Prabaha. Now, we all know that any technology can be a boon or can be a bane, and so as to say artificial intelligence, so as to say understanding it and also navigating it for the purpose, for the benefit of the humankind. Now, we all know that ultimately it is the human values that is going to stay, going to remain, and going to persist. And now this is going to change the norms of the society on the fulfillment of individuals' needs and desires. And also, it is going to create a new type of business opportunity. Both there are pros and both there are cons. And it is the right time for the law students, the law faculty must know all the nuances of these tools and technologies known as artificial intelligence. That there's a huge amount of copyright issues. Now there are layered AI that are coming up. That the origin of those AI's databases are not known. Who is controlling AI? There is no issue. We all know that. Yesterday, I learned that Copyright Act was later announced before the artificial intelligence was in existence. 1957, prior to that, artificial intelligence was in existence. So having said so, this Copyright Act and this new technology, artificial intelligence, present day Copyright Act cannot protect the interest of the persons. So there are, to me, there are 2-3 dimensions that needs to be flagged at this stage. First dimension, regarding the IPR, intellectual property right itself, different facets of the IPR, different law that is in existence about these issues of IPR. And second, the artificial intelligence itself, how do we protect the copyright of the inventor of the artificial intelligence? That's another dimension. The third dimension is that how the artificial intelligence is entering into the privacy of the people, or the damaging the privacy of the people, damaging the social ethos. And there are lots of news that are coming up. The use of artificial intelligence creating mocked images and getting into even the bedroom of the people. They are trying to create or simulate, and it is going to create a huge problem in the society. So that's a bane. Whereas the boon side could also be seen that people can now do many things with precision, with accuracy, with a less response time. So they are all logic-based, the way the human neural network they work, and those logics, if can be implemented, that is going to be a great boon to the society. Now at this juncture, with the philosophy of MIT University, as I mentioned there, that value-added courses under the Mulya Prabaha to be given to every faculty member once a year. So this year theme, we have taken that what are the different values are going to be created through this important topic, that is IPR vis-a-vis artificial intelligence. And what are the things that needs to be taken? What are the laws are in existence? What are the laws are not in existence? 87 IT Act cannot qualify, cannot give us the much more relief about this artificial intelligence and its intrusion. Then is there any need for, that also needs to be flagged in this, deliberations? Is there any need for going into further details, going into elaborate the deliberations and discussion to come out with the new IT Act including the new private data policies. So I think these are the right topics in the right time, and I must congratulate Dr. Saif Ali Raizada for encouraging the faculty members, Richa, Shelja, and other Rupinder and Rajat, that they to come forward and to formulate a 6 days value-added program of duration of 30 hours. Now, 30 hours, every hour, if we can plan it properly, it will bring different dimensions. I think at the end of the day, our objective, the way it has been planned, the objective must be satisfied with. That means the objective has been to raise awareness, that's okay. Second is highlight the legal challenges. To me, that what I was trying to say, what are the different legal challenges, as it is a layered approach that is coming up in the recent AI development. And it is developing very fast, very fast. Even the cycle time has reduced like anything. Then what is the interface between AI and IPR? We have to be very, very knowledgeable about it. And then what is the recommendation? Maybe out of this 5 days deliberations, can we find out some points which we can actually, recommend or suggest? Because this, I consider this value-added course is not only to give the awareness, but also do little bit of more research, so that findings can also be, communicated to the regulatory bodies, to the government of India, and also to identify what is the best practices that are available inside and outside the country. So this is most important thing to me. It's a very topical, very contemporary, and once again I must congratulate Dr. Balvinder Shukla, because she visualized that this type of things must be done. What others are not doing, we must do it. We should become the leader. And thanks to Dr. Raizada, I am also thankful to Dr. Aditya Tomar and Dr. Bhanu, because they are the strong pillars. These three are the strong pillars of Amity Law School, and with their involvement, the things are happening. And finally, on behalf of the Amity Universe, Dr. Raghavendra ji, I welcome you, and you are a great well-wisher to all of us. And here also, Richa approached you, and you could not say no to us. And that's a great, great love and affection that you have shown to us. I hope that with the involvement of the different faculty, different eminent speakers, dear participants, now I see that there are about 430 participants. The 430 participants, I hope at the end of the day, at the end of the 6 days, you are going to be enriched, and you will feel there are good amount of value addition. Then this success of this course can be judged. Otherwise, it should not remain as one of the course that has been conducted by Amity Law School Delhi. It should be the course which has been conducted by Amity Law School Noida. That's the most important thing to me. And if we can achieve it, then it will be the success. As it is worth spending 30 hours of our time, 30 hours of the speaker's time, 30 hours of the participants' time. So thank you once again, Besi ma'am, Dr. Saif Ali Raizada, and the faculty colleagues who are going to conduct it. And I wish all the best. And maybe in between I will also join. I'll see how the program is going on. So wish you all the best. Thank you. Thank you very much.
Thank you very much, sir, for your motivation. Now I would like to welcome our very beloved Professor Dr. Balvinder Shukla ma'am. Thank you so much, ma'am, for gracing this portal with your presence. It is indeed very, very honorable for us to see your presence in our program. I request you, ma'am, to kindly say a few words here.
My very esteemed colleagues, Professor Dr. B.K. Bandyopadhyay, Chairman, Amity Law School, and advisor to Honorable Founder President, all the HOIs, distinguished guests, faculty members, but most important, the students who are attending this value addition course. First of all, I would like to congratulate team Amity Law School under the guidance of Chairman Dr. Bandyopadhyay for conceiving and designing this very important value addition course. As Dr. Bandyopadhyay was at the beginning was mentioning the importance of value addition courses. There are two kinds of value addition courses. One kind of value addition courses are to develop the skills, general skills or the technological skills among the students. And also at the same time, creating the awareness. Second kind of the value addition courses are which are linked directly with the career progression of the students and which are basically progressive in nature, starting from the initial years till the final year of the students. As we all know that today the innovation, IPR, has become very important. And how that IPR can be protected is extremely important. And if you see today the chat GPT, you know that chat GPT is a solution to many things. You know, they can, and that is giving a lot of challenge to the today's creative people. And recently you must have seen that so many writers world over, they are making a representation that their jobs are at stake because of AI. Because if you use the AI tool, you can create the designs, you can create the write-ups, you can create the anything. So then how the professionals who have been, you know, creating the IPR will be able to protect their IPR in the age of artificial intelligence. Rather than many ways, AI is replacing the tasks or the work of those creative people. So therefore, the conducting this value addition course, especially for the student who come from the legal background, is extremely important because there will be very thin line to see what is the IPR and what is no more as a IPR. If today you start searching anything on the chat GPT, they click whatever is available till 2021. Based on that data, based on that information, chat GPT can provide the information, create a document, do all kind of things. So the day the data is updated up to the 2023 or the in future, the current year, so that means that you can get accurate information till the latest date. Today, also when we talk about the IPR, you know, we had so many things in our country, the knowledge which were there, which was considered as a traditional knowledge, and it was never registered as a IPR or was never patented. And the people in the other countries, they started patenting, we all know that whether it was our haldi, whether it was our name, and so many things. And but it was the expertise of our legal fraternity who could fight for the basmati and all. So that means that in future the fight for the IPR will be even more intense than what it has been in the past. And I really congratulate Dr. Bandyopadhyay ji and his entire team of law institution for coming up this value addition course on navigating IPR vis-a-vis emerging concept of artificial intelligence. And I'm sure that the workshop will give a lot of insight to all of you. And on completion of this course, you will be able to understand as a lawyer, as a legal person, what course of action you have to take or how you will be preparing your argument for the IPR. So this is something which will be very much in demand in times to come. So therefore, the capacity building, what Dr. Shafali Rajada was saying at the beginning, the capacity building is very important. And at the beginning of the academic session is beginning next week, but just before the commencement of the academic session, this 1 week workshop, I think it will be very, very helpful for all of you. During the academic session, your institution will be, and your university will be conducting the large number of value addition courses. My advice to all of you is that please look for any value addition courses which is being organized by Amity Law School or any other institutions of the university. You must attend those value addition courses for enhancing the certifications, which will be very useful for you tomorrow for your employability. Whether you are going to go for your corporate career or whether you are going to start your own ventures, and or whether you are going for higher education or competitive examinations, because everything cannot be covered in your curriculum. Whatever is being taught to you in your programs. So therefore, additional knowledge, the skill development, competency development is extremely important. And if you take advantage of those opportunities which you will get during your education at Amity University in the form of value addition courses, that will be very, very useful. I would also like to advise all of you, if you have not yet updated on Amazon your career aspiration, my advice to all of you that you please update your career aspirations on your Amazon, because your institution, while developing the value additional courses for each aspiration, you must attend those relevant value addition courses for your progression as per your aspiration. With this, once again, I congratulate team Amity Law School and the chairmanship of Dr. Bandyopadhyay ji, and wish all the best and have great learning and your professional development during the value addition courses. God bless you.
Thank you so much, ma'am.
Thank you, ma'am.
For being a part of the event and blessing us. This course is your envision, and we are just carrying forward what you have guided us to.
Let us all give us a huge hand of applause to her.
Now, without any further ado, I would like to request our very guest of honor, Dr. G.R. Raghavendra sir, to address the participants and share his valuable knowledge with one and all present here.
Thank you, Richa, Hare Srinivasa, Vande Mataram. Good morning to all distinguished Amity family, Chairman Dr. Professor Bandyopadhyay ji, Vice Chancellor Professor Shukla ji, and Professor Aditya, Professor Arvind, Professor Shafali, Shailaja ji, and Richa, who has invited me, and all of you, and all the assemble students. About I see about 450 odd participants are there, and happy to see all of you. Welcome to the world of intellectual property and its interface with artificial. And whenever I participate in workshops or read a lot about interaction with interface between intellectual property, you take a patent or copyright, and people start talking about, oh, it's a great area. AI is going to change everything, and it is a danger to patent in inventorship and copyright law. Who is the inventor? Who is the author? And whether AI itself to be recognized as inventor or AI itself is an author. You know, all chat GPT things. And out of 450, I understand that more than 400 must have already attempted chat GPT and downloaded or subscribed or having fun with it. And there are other AIs. You need not prepare a PowerPoint presentation. There is a AI, slides AI, it prepares, you just give data and it will prepare for you. It's a beautiful presentation, even a professional computer knowledge guy may not prepare. So like this, the various disruptive AIs have come. It all started with the machine learning or natural process learning, these algorithms. Now, not only the learning from the available the content, and the artificial intelligence converts text to speech, speech to text, and whatnot. And the new deep learning or neural visions and generative AI. This is the day. You must have heard Mid-Journey or Stability AI's new model called Stable Diffusion. All these create humongous piles of legal problems, and people say it's a gray area. What I say is, don't get confused with artificial. It's, its intelligence is not comparable with the human being, and it is only artificial intelligence. What is the difference between this technology and human is, human takes some time to produce his output, and whereas artificial intelligence does it within seconds. That is the only distinction. And artificial intelligence, it's not going to replace. Please mute your mics. And it's not going to replace human. It is only a general purpose assisting technological tool which is going to improve your functioning, your work. If you don't adapt and don't learn how to use this artificial intelligence technology, whether in academics, you are teaching, researching, or working in any market-based, business-based, or services-based in industry, even innovating, disruptive, innovative, technology-driven industries, or financial sector, banks, everywhere it is going to be an assisting tool. It is not going to replace. It only replaces that lazy person. I don't want to learn. Then he is gone. He may be replaced, but not by the machine, but by another smart guy who has learned how to use these technologies to give better results. That's what's going to happen. Now, let us start one by one. how it is affecting IP. I am the one for the past so many years since this AI problem has started. Since Naruto versus David Slater, the PETA versus David Slater case came about whether Naruto monkey has copyright. From those time, I'm arguing that a machine is not a human being. Don't try to put spirit into machine and equalize with a human being. Try to grant rights to machine. We already had a big problem with PETA, which wanted all the rights in a selfie taken by a macaque monkey called Naruto in the Indonesian jungles when David Slater kept his tripod and the camera ready, and Naruto came and took beautiful selfies smiling. And then when he wanted to monetize, in fact, he started monetizing those photos. PETA opposed. As per the definition of the copyright, the person who takes the photo is the author of the photograph. The copyright in that photograph, it will go to that person. PETA argued that David Slater kept the tripod and on that camera fixed, but photo was clicked by monkey itself, Naruto, copyright goes to. But PETA lost the case in the first instance district court and Court of Appeal in United States. The both courts supported the argument of David Slater's lawyers that a person clicking the button you will get the rights. Now, when you click the camera, you are the person. Okay. Or you ask someone to on your behalf to take a photo. So monkey is not a person, animal. Animal can't have rights. No law in the country, either India or any other country or international convention, define person as an animal. Person is a person. Person maybe, you just read the section 347 or subpara of the General Clauses Act. What does it define a person? Person means other than a natural person, legalistic or a juristic person, an institution like Amity University, it's a person. It's a legalistic person or a juristic person. If Professor Shafali, Professor Aditya, or Professor Avrivind write the annual report of Amity, what is the Copyright Act says? Section 17 says, first owner of the copyright is the person whose expression is written. So if these people come out with an annual report, there is a work of joint authorship. Two or more persons, again persons, collaboratively writing a report. So first copyright goes to these people, Professor Shafali, Professor Arvind, and Professor Aditya. But they are employed. Again, Section 17, para 2 Section 17B says that those who are on contract of service, they're getting a salary. So where employer gets the copyright in the report prepared by Professor Aditya, Professor Arvind, and Shafali, not they themselves. Even though first owner of copyright is the authors. These are the three joint authors. The right will go to Amity University, which is the institution and which is a person in the sense legalistic person and juristic person, not a natural person. So this is the beginning. So copyright law, whether our national legislation or international conventions like TRIPS and Berne or the WIPO copyright treaty, the first internet treaty, which extended the protection of physical protection of copyright, which was designed in the Berne Convention in 1886, which has been amended 7 times. The final text is 1991 Paris Act that revised Berne Convention, which has been included in the TRIPS. Article 9.1, what does it say? That Article 1 to 21 of the Berne Convention, excluding the Article 6 of the moral rights, as the part of the TRIPS. Whereas WCT mentions that Our entire Article 1 to 26 is part of the WIPO Internet Treaty. So question comes whether invention, before I jump to the copyright issue, let me complete the patent inventorship. First, you begin with the invention, where invention is protected and a patent is granted in any field of technology. That's what Article 27 says. Patent shall be granted in any field of technology. This is ICT, the most disruptive IA technology, whether process or a product, provided it has novelty in industrial application. So I give you an example of Stephen Thaler. He invented artificial intelligence, generative artificial intelligence machine called Davos. So who is the inventor of the Davos? It is Stephen Thaler. He got the patent. Now, problem came when the Davos, the generative AI itself started innovating and creating, inventing a food processing technology device. Then who will get the inventorship? It is Stephen Thaler or the food technology inventor, this Davos mission. So he wanted to test. Stephen Thaler filed an application in USPTO office where it was rejected that patent shall be granted to person. Inventor is a person, not a machine. That's ended. That's matter ended. But people still talk that gray area. I'll come to that gray area. Why they talk about it. Then he went to UK patent office. He lost. He went to EU patent office where he lost. And only one place he got the patent inventorship recognized, that patent granted, that is South African Patent Office, because their examination method is not on par with the universal practices followed in US, EU, UK, India, elsewhere. But similar mistake which South Africa did, done initially by the Australian Patent Office, but later that grant of patent was challenged in the Superior Court, appeal court, where 5 judges bench sat and they gave the same decision which other nations are saying. The inventor has to be a person, a natural person, not a machine. So, and then what happens if such algorithms or inventions are not protected, if some secrecy is there, that can be protected in the trade secret. That's what I have argued in my PhD. Because unfortunately, India, there is no sui generis standalone trade secret law. All the trade secrets are protected under Section 27 of the Contract Act by way of non-disclosure agreements. But that is not sufficient. It doesn't give a deterrence when infringement is done. And a strong secret law is the need of the hour, especially in this disruptive technological innovations are happening. And most of the data-driven environment is there, whether the data created in the industry 4.0, where machine-to-machine manufacturing is happening. Earlier was man-to-machine manufacturing. It is machine-to-machine. That is, AI is taking over entire manufacturing. Lot of data is being created, and if data is created in that not patentable, it has to, there is a secrecy in this data, because it may be helping the marketing or financial sector, or put the that product in the market in a dominant position, so that the competitors won't steal that data and destroy his market. So trade secret is important. Then coming to the famous copyright issues, where you are facing as an academician every day. What is the issue? Now, you as a professor, you give a deadline to your student or a researcher to write an article in 5,000 words. So he will ask ChatGPT to do that. ChatGPT will, within seconds, it comes out with 5,000 word article. So who is the author? That question. So most of the generative AI creators, whether it is the OpenAI who created ChatGPT, or the Google which has created Bard AI, and Microsoft which has created Edge, and which is coming out competitive generative AIs to defeat the marketplace of ChatGPT and others. There is a competition rush there in the creation of ChatGPT, which is the best generative AI, whether it is a Bard or Edge or ChatGPT, and there are various versions available and in the market in the entire digital environment. So, who is the author? Whether the generative AI itself an author? Before I go further, I also follow the same concept of only natural person getting the authorship of copyright, similar way of inventorship of it. Why? You see the entire history, development and evolution of intellectual property rights. Why the exclusive rights have been given to an inventor who is a human natural person, author who is an author who has written most entertaining knowledge based books to us. He again is a natural person. So why exclusive rights? 20 years exclusive rights for patent, life of the author plus 60 years in India. This has come to give incentives to these inventors, creators, and authors, so that because this inventorship and authorship has become a profession for them based on the royalties, based on the profits, based on the compensation they get when this work is copied and utilized by others. These incentives make them live comfortably so that using their beautiful brains, they can invent further. If a ChatGPT 3 was there, now 4 has come, tomorrow 5 may come. So all these things done by humans only. Okay. Similarly, the various books written by you, the first owner of the copyright, the author has to be the copyright owner, but not the machine. So incentives are given to you. And also there is a utility incentive theory is the main backbone of the intellectual property rights. You take any intellectual property, whether industrial property rights, patent, trademark, design, or semiconductor, industrial layout, or copyright and related rights. Here we have humongous kinds of authors and creators, whether authors of literary works, authors of dramatic works, authors of artistic works, and music composers, and creators, producers of music recordings, producers of films. All are humans. Okay, and then you come to the performers, whether actor, a singer, everyone life is threatened because of artificial intelligence. And people unnecessarily saying that there is a gray area, Copyright Act 1957 is not sufficiently protecting. No, it is protecting. The amendments carried out in 2012. I know last week only I wrote an article on the 11th anniversary of the amendment to the Copyright Act 2012, in which I argue that all the issues of artificial intelligence and the problem posed to the authors and creators has been completely addressed there. The provisions already are taking care of the rights of authors and creators and singers and other people who are creating copyrights and related rights. Only thing is a minor tweaking is needed. That I'll explain you right now in a nutshell. Number one. And number two is utilitarian theory. whatever has been created for the utility of the human beings, considering this, what I am creating is going to help to be come to the utility of the society. That kind of thinking is there in human, because when COVID came, everyone has rushed to create vaccines. Whether Pfizer, Moderna created messenger RNA vaccine, or Honorable Prime Minister Modi thought from Pfizer and Moderna, we'll be selling our sovereignty and independence to foreign companies. No, we'll have Atmanirbhar vaccine. The Bharat Biotech came out with the Covaxin, the dead virus, antibodies created out of a dead COVID virus, or vector virus licensed vaccine of AstraZeneca, Oxford, of the Serum Institute of India in Pune, that is the Covishield, or our own Atmanirbhar medicine, the DNA variety of vaccine developed by our generic pharma producer from Gujarat, Jadis Cardila. So all these things have been done by humans to help the humans. Some utility is there using this innovation. So that concept won't be there in AI brains. Then comes the personality theory. Entire intellectual property rights are inextricably associated with the personality. Especially it is more in the copyright, where author creating music, or as artists doing painting or singing or acting. This is extension of a personality, human personality, because it differs from the person to person. So that you see the every actor, whether you see the Hindi actor, Tamil actor, Telugu actor, or Hollywood actor, their personality, each and every individual personality is expressed in a different manner, where you don't find in a machine, non-human AI. So please don't compare AI with human beings, and don't put human spirit in the AI and started treating it equivalent to the human, and don't fall into the bogey of the people who are arguing for their own selfish business interests. Because I know there are some arguments from OpenAI or Google or Microsoft. They want to take over the rights, whatever inventions, creations, innovations are doing, because sitting in the in your computer, desktop or laptop, or in your mobile telephone, these apps are not entering your brain and understanding what your need, and then without your prompt, prompt may be the textual prompt or voice based prompt. Once you give a prompt, whether text or voice prompt, then only ChatGPT creates for you. That too, one has to be an expert prompt giver. Otherwise you don't get satisfactory end product from this ChatGPT. So these are the things, arguments I say that only humans should be given copyright. Then move next. You see the authorship. I go back to the same story, hypothetical, where Professor Aditya asking his students to write a 5,000-page project report on interface between IP and artificial intelligence. The moment researcher or student gives a prompt, whether it's a text prompt or a voice prompt to the ChatGPT or any other available generative AI, what happens? Within seconds, it comes out with the end product of 5,000 words. Then author, do you think that author is the machine? Granting an authorship is the machine. And again, there are three kinds of thoughts. One is the revolutionary school is there, their property-based approach, like our open AI, already give you example of Google, and you take the Microsoft, all the creators, the entrepreneurs, the big companies, MNC companies, they want to capture it, giving the rights to the machine. That is one school is there. And second school to which I proudly belong, that is romantic conservative school, in which it is a non-property based approach. We say that a machine has to be the author has to be a natural person, and a machine, a non-human, cannot get a copyright, whatever it has churned out, created. Because the prompt you given, then only it is creating it. And if you see the section 2, subsection 3, subsection C 6, which the definition of the artistic work, where it says that for computer generated works, because AI creating a 5,000 word project report for you, it is a computer generated. For such creation, person behind that a computer or artificial intelligence who is giving prompt is the author, not machine per se. Then comes the third school called modernistic school. These people are property balance approach guys. These people want to give ownership to the creator or a designer who has written that source code and object code and created that generative AI, and person who has funded, like the OpenAI or the Google or the Microsoft. Then third comes the person who has used that. So like this, they want to give rights to everyone. वो तो होने वाला नहीं है. So then go to the issue of reproduction. So what ChatGPT is creating an article or a project report of 5,000 words is a copyright infringement is there. So all the authors in the world, especially America, they've gone to the Supreme Court, various cases they have filed against all these generative AI creators like Stable Diffusion, Midjourney, and all that. What is this problem? They say that the very AI learning itself copyright infringement. They said, my books are available. Copyright is subsisting in that. How generative AI learns from that stuff, copyrighted material, without consent and compensation, that is infringement of copyright. What I say is that argument is incorrect. If you go to the WIPO Copyright Treaty 1996, the very first article of the WIPO Copyright Treaty, which extends the reproduction rights of the authors from the Berne Convention, physical environment to the digital and online networks. In the Article 1 of the WIPO Copyright Treaty, it says any conversion of a physical book into digital format is reproduction. Okay, that's what ChatGPT is doing. Already it has been converted. It won't go to a physical book which is lying on in the table and start learning and reading it. This very book has to be digitized and made available to ChatGPT in the online network or on your computer database. Otherwise, it can't read and learn and create data sets. How it creates? It's basically a kind of text data mining, natural language processing. It first reads it and it classifies it, categorizes it, and creates, and also sometimes text extraction it also does. And finally, it tokenizes it because a classification depends on tokenization. For example, I want is there. It creates two tokens. I is one token and want is other token. Like this, each phrase word it tokenizes, classifies, and then it memorizes and stores in its medium. So in how it stores, it creates various data sets. So very creation of data set, because it is a reproduction from the original content written by author, whether it is a copyright infringement. So when it creates the final product, just like Professor Aditya said, ask the student to create 5,000-word project report when end product is coming, where even though educational research purposes copyright infringement is not there, exception is there, you need not take permission from the authors and publishers, various books and articles you are referred to, but you have to give citation, whichever citation method your university is following. But where is the citation? When ChatGPT or any generative AI creates, it gives you end product without citation, any reference. That is plagiarism, high-tech plagiarism it is. Then you have to go back and ask, my professor will kill me and disqualify me from law. Please give me the referencing for 5,000 words you have written for me. And it starts buffering. It will give 5 or 6 referencing, which is not sufficient at all. And whatever referencing it has given, citation, you try to read, try to locate that in that source. You won't. Very difficult. Sometimes it gives wrong information. We have to be very, very careful. Recently, one American lawyer, he asked the ChatGPT to write affidavit for him in a legal case. It did write, and it came out with 6 case laws to support his argument. A poor fellow, without fact checking, and he filed in the court. Now $5,000 fine has been imposed on him for filing the wrong information. Judge said, I have to break my head. I did not find all these 6 cases you referred. None of the court in this world has given such judgments. From where you have brought it? Then this guy, with folded hands, requested the judge to pardon him. Sir, ChatGPT has created it. I believe such case may be existing. That's why I have filed it. But ChatGPT has given bogus cases, false cases created by it. So you have to be very careful. So high-tech infringement is happening, high-tech plagiarism is happening, and also the ethics and morals also question the person is using it, because it is a machine. You can't blame it. Then question comes, the argument of author saying that the very learning is copyright infringement because without consent and compensation it is left. No, because you buy so many books in the market and subscribe so many articles, you read. When you read, you may take points in your notebook, or you may memorize it. So how come something embedded in your layers of your brain, and that is a reproduction considered, that learning is infringement of copyright if you don't take permission, consent, and pay compensation? That is my argument. So what I have argued in my article and also recent my presentation in the comparative law conference of America and Asian countries, where top copyright and AI experts were there, including Google, Microsoft, and other corporations. What I said, Indian copyright has given exception to such thing. Any transient and incidental copies which your computer database is making while learning that, while you are navigating the website or trying to read the website, everything is transient, incidental copies made in your computer. Such copying is not infringement of copyright. That's what we have written in the 2012 amendments. Before AI came, we have done all these things. Now all these are applicable to AI. So don't think that in the wrong impression that 1957 Copyright Act and 2012 Copyright Amendment not addressing these issues. Entire provisions are addressing these issues. There is no big problem. So all rights are with the humans. No infringement is happening, and education institutions or individuals need not worry. So how it is legal as per the international law? Again, I take you to the Article 10 of the WIPO Copyright Treaty, where in the agreed statement, what is the Article 10? Let me explain. It says all the copyright exceptions and limitations in the digital environment can be extended, provided only for the certain special cases where it does not conflict with the commercial exploitation of the work, or it does not is not prejudicial to the rights of authors. That is the three-step test which has been adopted in the Article 13 of the TRIPS and which originated in the Article 9, Para 2 of the reproduction right exception given in the Berne Convention, which was being included in the Berne Convention in 1967 revision conference held in the Stockholm. Berne Convention came in 1886. These things were included in 1967. And again, a change in 1995 in TRIPS. And the WCT went ahead because it is internet treaty. It said in the agreed statement, member states can give any exceptions when new technology comes. That's what India has done. In 2012, the transient incidental copies stored in your mobile or database, laptop and desktop is not infringement. When AI is doing learning itself is not infringement of copyright. That's what argued in the Tokyo conference, and also which I published an article in the LinkedIn and shared in various social media accounts. So that's there. Then comes the issue of the singers. Most of the singers are worried. Music composers are worried whether it's in Hollywood or Bollywood or in India is not Bollywood. One should know that. I come from the Andhra where the films have become world famous, whether it is RRR, Bahubali, the Kannada films, Telugu films, the Tamil industry and Malayalam industry, Bengali, Gujarati, Bhojpuri. It is wrong to say India is only Bollywood industry, but there are music composers, there are filmmakers, there are singers, multiple language singers. Their job is gone now. I'll give you an example. There is a the stable diffusion or mid-journey. These are the generative AI, artificial intelligence machines. It can sing like Mohammed Rafi or Lalita Mangeshkar, who passed away. Let us say that Dr. Shafali is a very good poet. She writes a song for Amity School as an Amity School anthem. Okay, if she has written that and she wanted that has to be sung by Mohammed Rafi and Lata Mangeshkar, unfortunately, they have passed away. How to do? These artificial intelligence, generative AI machines can learn. If you feed hundreds, thousands of Mohammed Rafi songs and Lata Mangeshkar songs, these stable diffusion and mid-journey learn how to mimic their voice, their arohan ho, avarohan ho, rag alap karna ho, majedar gana ho, or विषाद की आवाज निकालना, दर्द भरी आवाज निकालना, सब सीख लेते हैं. And then the moment she gives Dr. Shafali feeds her song and gives a prompt, immediately a duet तैयार हो जाएगा, sung by Mohammed Rafi and Lalita Mangeshkar. Immediately, she either give it to the university or she may upload on the YouTube and start monetizing it. And she will say that it is an original song written by me. Of course, she has a copyright in that lyric. An original song sung by Lata Mangeshkar and Mohammed Rafi. But they are not alive. Kaise gana gaya? It is mimicked and sung by whether mid-journey or stable diffusion generative AI machines. Immediately, उनकी लीगल एड्स जाके कोर्ट केस डाल देंगे, भैया हमसे कंसेंट नहीं लिया, हमें कंपनसेशन नहीं दिया. If a dead person songs you use, let us say that she has not used the dead persons. She has used Sonu Nigam and Shreya Ghoshal. The moment song is released, both Sonu Nigam and Shreya Ghoshal are surprised. Oh, it's my voice. But मैं तो गाया नहीं. When did I sing that? It's my voice. All kind of harkats, all kind of sur, ऊपर लाना, नीचे लेना, और गाने में जो भी अपनी कलाकारी दिखाना. They have done that. The AI machine has done that, but they have not sung. Whether it is legal, whether infringement of copyright. The moment Sonu Nigam and Shreya Ghoshal file a case against Dr. Shefali, not taking a consent and paying compensation, Dr. Shefali's lawyers, to speak about basic copyright, they go to the performer's definition. What is performance? So here only the way the song is their performance, the song sung by performance. Okay, and they will say it is not sung by a human, and it is sung by machine. It is copyright protected or performer right protected. On 2 counts, Dr. Shefali, I'm sorry to say, I'm using your name as a hypothetical situation, Shefali ji, and Dr. Shefali lose this case on 2 counts. One is what stable diffusion or Midjourney is doing. It is a derivative work it is creating. It is not a original work. Converting their voice, learning and mimicking and singing, it is a derivative work. Number 1. Further consent and compensation. And it will also attracted by 31C, where 31C version recordings are there. Where version recordings, a statutory license has to be created, fixed by the regulator. Now there is no copyright board, no IPAP. In Tribunal Reforms 1, Copyright Board was merged with the IPAB, and Tribunal Reforms 2, IPAB was abolished, and the rights and jurisdiction of this regulatory body has been given to the commercial bench of all 25 high courts. Being there from Mumbai, Sonu Nigam and Shreya Ghoshal may file a case either in commercial bench of the Mumbai High Court or in Delhi High Court. Then what is the version recording thing argument? In section 31C, statutory license for version recording. Any person singing the version song of the original singer has to do that only after 5 years of release of original song. No, you can't create a new song. That is not allowed in their voice. So if you are singing a new song in their voice, it is a derivative work, or singing an old song with a new things added to that in the version recording, then that has to be done only after 5 years. That too, the commercial bench has to fix a royalty. So these are the legal position which address these things. So again, I want to say that no machine, artificial intelligence machine, whether it is the low AI machine, no, weak AI is there at present, or low AI is there. These weak AIs and low AIs are creating humongous problem. Imagine tomorrow strong AI comes, high AI comes, but still it may be thinking the more autonomously without your prompt. I read in newspaper, Elon Musk is, Tesla is investing humongous amounts of money where machine, artificial intelligence, machine to human brain connectivity. So the moment you think, I want this, machine will come out with the product. So that kind of thing is going on, research. So still there, only the human is prompting. So it has to be human, human, human. So what is the alternative then? Then you may ask me, Dr. Raghavendra, you are not allowing the AI machine to get copyright or AI created works to get a copyright. What should be the alternative? What I say. So all the work created by Professor Shapali, Professor Aditya, Professor Arvind, Richa, others, taken because they are paid employees of the Amity University, and Amity University owning all the work created by them, not the books or articles privately written by them. Obviously, that is the copyright ownership goes to all these individuals. But when Amity University gives administrative orders to them, prepare this report, prepare this project officially, for which they are paid as an employee. So thus copyright going to the institution. What is the copyright duration for that? Any institution will get the 60 years copyright as a legalistic juristic owner, or author transfers the rights to them. The life of the author, 60 years goes to them. So such kind of arrangement to be done, a guidelines has to be issued. That person behind the creation of computer generated work should be the owner. And you know what, our copyright, I end with the big mistake our copyright office has done recently, which my colleague Shira Palmater from the podium in the US Asia Comparative Law Conference in Waseda University, Tokyo, raised this question to answer in my speech. I'm giving you this and with before I end my talk. One Ankit Sani, a friend of mine, young and brilliant advocate, filed an application for copyright in Copyright Office at Dwarka under CGPDTM Office, DPIIT, Minister of Commerce and Industry. He said, one work, which is a combination of Vincent van Gogh, expressionist Dutch painter of 19th century. His painting famous is Starry Eye. He took the Starry Eye painting photo from the internet. He took a photo of Goa, a sunset photo. These two photos he fed to an Indian generative artificial intelligence machine called Raghav AI. It's not me, Raghavendra, because the creator is Raghav Agarwal, other person. So that Raghav AI created a new work. It's a mix of these two things, a beautiful painting, and they called it Suryast. They give a new title to AI generated work, Suryast, and filed it for the copyright. So हमारे copyright office वालों का थोड़ा सा दिमाग घूम गया. They're confused. Poor people to whom copyright has to be given. Finally, they decided, because if somebody has given prompt, that is Ankit Saini advocate, but created by Raghav AI. So they declared Raghav AI as a co-author of Ankit Saini advocate. They are given joint authorship. They issued copyright certificate. That is a big mistake. Why big mistake? You go to section 2Z, definition of a phrase, work of joint authorship. It says, two or more persons, okay, two or more persons collaboratively creating a work, maybe writing article, two or more persons. You know, you academics or researchers, students, you know that two or more, you come together and write an article and write a book. Then you are the joint authors, not a machine. Machine is not a person. It is a non-human. It can't be given authorship. So that is the big mistake. When it was pointed out after certificate is signed and granted, so how come machine is a person? They, you know, they got scared. They withdrew the registration. And they said, so that is another mistake. As per the Copyright Act, section 47, if I'm correct, rectification of copyright has to be done by the regulator, not by the registrar of copyright. Registrar of copyright has right only to register the copyright and give a certificate on. any rectification. You can do small error correction. Naam mein spelling galat ho gaya, address mein galat ho gaya, something, those kind of correction can be done. But entire deletion of the once registered from the register has to be done by the Commercial Code Delhi. What Register of Copyright exactly done is to move a suo motu application to the commercial bench. Sir, हमारा गलती हो गई, affidavit में you must inadvertent mistake. We are given joint authorship to the machine. That has to be deleted. Only the authorship is recognized for Mr. Ankit Cheney, advocate only. Copyright has to go to him. This has to be deleted. Machine as a person to be deleted. That has to be accepted by the court. That too of the arguments, a notice should have gone to the person who has given this, person who has been granted joint authorship, and he should have opposed. After argument, the decision would have come in favor of the Copyright Office. Okay, now you can rectify and delete that. Without this exercise, they simply issued an order. It has been withdrawn and deleted. That is another mistake. So finally, I say two things. Don't put spirit in the artificial intelligence. Don't treat equivalent to human being. Don't give unnecessarily machine rights and create problems for humans. Number two is when you use ChatGPT, be ethical and moral and do citation. It may reduce your work and time, or you can use any other algorithms. There are text extractions are there, paraphrasers are there, text summarizers are there. There are many tools are available. You must be already using it. You use that. It will reduce your time, but do fact checking, number one, before putting in your work, and do give citation and referencing. Respect copyright of others. So with this, and thank you very much. Jai Hind. Wish you all the best for the great venture taken by the Amity University Vice Chancellor, Chairman, and professors. Wish you all the best. Jai Hind. Thank you.
Thank you so very much, sir, for gracing us with your presence. It was very, very wonderful to listen to your talk on AI and copyright. Thank you for enhancing our knowledge in the field. Thank you so very much, sir. Dr. Gargi is here. A very warm welcome to you, ma'am. Ma'am, you are on mute.
I think it's good afternoon.
Yes, ma'am, it is good afternoon. Sorry if I said
Okay.
morning.
It's good morning for me, so that's why just asked. Yeah.
Ma'am, we would be starting with the technical sessions in 5 minutes time. Thank
No
you.
issue. I'm here only.
Okay, ma'am. Thank you. Over to you, Shelja, ma'am.
Good morning, Raghavendra sir.
Good morning, Gagi. How are you?
I'm good, sir. I'm good. How are you, sir?
Fine, thank you.
Thank you so much. First and foremost, Dr. Raghavendra sir from Amity Law School and Amity University, and from all of us here. Sir, your lecture session has been an academic ideation of all the knowledge realities and practical alignments that we are seeing today in the field of intellectual property rights and its convergence with the artificial intelligence. You have taken up so many practical ideations that are coming up in artificial intelligence. It was a very contributing knowledge resource for all the teachers, academicians, industry people, and particularly, especially for the students who are into this research genre of writing, referring, and going out and taking from national and international legislations on copyright and all other aspects, combining all the practical knowledge out there and what are in the books. So thank you so much, Dr. Raghavendra. We are really honored and pleased to have you, sir. And we are looking forward to have you back again at Amity Law School, Amity University, Noida, sir. Thank you so much. If there are any questions, Richa ma'am,
Okay.
ma'am, Tanmay Tiwari sir has raised a question.
I think we can take up this one question, and with this we can end the inaugural ceremony and can start with the technical sessions after that. So if you may allow. So the question reads, the CEO of OpenAI, Sam Altman, has expressed his concerns before the US Congress regarding the decentralization of machine learning platforms. Do you think there is a need of legislation in regulation and usage of artificial intelligence? If yes, could you please suggest some groundwork on how to go about it?
Yeah, many countries are coming with the AI Act. EU has come up already. And for instance, EU has mentioned that the machine learning is happening. So what is the source that need to be mentioned? For instance, if the same example, I say that when a researcher, a student asking the 50,000 words or 2,000 words article to be created and given to you, the end product. So it has to clearly mention, list out. And so that helps to avoid plagiarism also. There is a ethical also. So you in the machine learning has learned from which sources? Because in the internet, there are three kind of sources: the copyright subsisting works, which are legally available, and number two, public domain works, they are out of copyright works, which are freely accessible. Third one is, pirated copies, which have been unauthorizedly uploaded in the internet. So ChatGPT collects all this information. This has to be clear. So, and this is the one. Number two, there are machine learning, various techniques are there. So which are the techniques it has adopted? So in creating data sets, which data sets going to give you the end product? So whether it has involved in text extraction or categorization, classification, etc. Problem with the text extraction is many of the copyright protected works are protected by voluntarily digital rights management have been put there. Voluntary restrictions have been put by the right owners and authors. I know they have put the restrictions. Best example is Netflix, where you can access only, use register. After register, you subscribe with a password and a login and a password. And what happens? AI is breaking that. Something voluntary protection measures you are imposed on that. AI is breaking it and extracting that content and giving it to you. So all these things, the model has to be done. I support the thing is what government is thinking. But one thing, whatever regulation as policy comes, national IP policy, there's a Creative India and Innovative India. So these innovations of AI done by OpenAI or Google or Microsoft or any other multinational or our national tech bodies, that has to be supported. They should not be threatened in the name of copyright or a patent, but this should be balanced approach should be taken by the policymaker. We should encourage them to use these technologies, but there should be some transparency should be there. That kind of policy should help the copyright owners and inventors and also these tech creators. Yeah.
Thank you, sir, for your answer. With this, we move towards the end of the inaugural ceremony so that we can proceed forward with the
Thank
technical
you, all of
session.
you. If I am permitted to take leave, thank you. Jai Hind.
Thank you so much, sir. Thank you. So at the end of the ceremony, I would like to propose a small vote of thanks from myself, Richa Yadav, and my co-convener, Ms. Alaknanda, in her absence. I want to thank our founder president, sir, our chancellor, sir, our vice chancellor, ma'am, chairman, sir, our additional HOIs for their continuous support and blessings, which has made this event a possibility. With this, I thank all the participants also for showing their enthusiasm and being present throughout the inaugural ceremony. A small announcement, the technical sessions would continue from now on. So from 2:40, we would be starting with the technical session that will continue for 1 hour and 15 minutes. Post that there will be a lunch break, and after that there will be one more session. Thank you so much. Thank you so much, sir, for being there. Sir, if you allow, then can we close the session for now? Sir, you are on mute.
Let the next session starts.
Okay, sir. Okay, sir.
The same platform or other platform?
No, sir. The same platform would be there for all the sessions this
So
day.
let it
further
start.
days. Okay, sir. Okay, sir. Shelja, ma'am, over to you.
Thank you so much, our convener, Richa ma'am. Now, as we step into the day unfolds with the next technical session by Dr. Gargi Chakravarti. After the economy of knowledge and practical realities of intellectual property rights and its convergence today with the artificial intelligence and with the various practical and knowledge nuances of AI, we at AMT Law School, AMT University, Noida, on the behalf of all the esteemed dignitaries and all my professor colleagues and all the registered participants, I welcome Dr. Gargi Chakravarti. Ma'am, a very heartiest welcome. Thank you so much for joining us. And we are really indebted to have here some words of thought and wisdom from you. A brief introduction. Dr. Gargi requires no introduction. I was reading her profile. Ma'am is at the epitome of intellectual property law from London, UK to India to Jodhpur and to Noida now. Ma'am has obtained LLM, Masters in Law from London Metropolitan University in a very diverse field, comparative intellectual property law and international law. Ma'am has obtained her doctor in PhD in intellectual property law from NALSA. She is currently holding associate professor at NLU Jodhpur. Thank you so much, Dr. Gargi, ma'am.
Thank you for your kind introduction. I have one question before
Dr.
starting.
Gargi, welcome, most welcome. We are really obliged and really appreciate your presence on this platform. Thank you so very much. And
Thank you,
once again,
ma'am.
welcome to you.
Thank you so much, ma'am.
Yes.
I just want to ask Richa, how long I have time?
Ma'am, the session is for 1 hour, which will be followed by question and answer round. I think that will take another 10 or 15 minutes.
So total 1 hour, 15 minutes. I mean, 1 hour I have time, correct?
Yes, ma'am. For you to speak,
Okay.
yes, 1 hour.
Yeah.
But,
Okay.
ma'am, with the knowledge that you hold, I think 1 hour would not do justice to your
It's
lecture.
okay. Okay. Actually, during my PhD, my PhD topic was access to medicine. So that's why I have a keenness to regular research on that related topic. So today again, I have taken the legal and ethical issue of AI related with healthcare system, maybe a bit different than the other topic. So I like to, but in a very simplest language, and everyone can understand what are the issues we are going to face in this manner. Now, the legal and ethical issues that confront society due to artificial intelligence, Raghavendra sir also emphasis on that just before me. So here the privacy, surveillance, bias or discrimination, and the philosophical challenge as a role of human judgment is there. Now, the concern about this newer digital technologies becoming a new source of inaccuracy, data breaches, so mistakes in the procedure or protocol in the field of healthcare can have devastating consequences for the patient who is the victim of the error, because patients come into contact with physicians at a moment in their lives when they are most vulnerable. So it is crucial to remember that currently there are no well-defined regulations. Just now we have talked about it in place to address the legal and ethical issues that may arise due to the use of artificial intelligence in healthcare settings. Now, the thing is like that, we know that increasing patient demand, chronic disease, resource constraint, it's a huge pressure on healthcare system for further development, more development. Now, simultaneously, the usage of digital health technology is rising. Okay, there has been an expansion of data in all healthcare settings. Now, properly, healthcare practitioners could focus on the cause of illness and keep track of the success of preventive measures and intervention. So, as a policymaker or as a legislature and decision makers should be aware of this particular segment also, that healthcare is as well as using this AI related because of the development demand. Now, computer and other decision makers should be, data scientists, clinical entrepreneurs argue that one of the most critical aspects of the healthcare reform will be artificial intelligence, especially machine learning. Now, artificial intelligence is a term used in computing to describe the computer program's capacity to execute tasks associated with human intelligence, such as reasoning and learning. It also includes processes such as adaptation, sensory understanding, interaction. So, traditional computational algorithm simply expressed that software program that follows a set of rules and consistently do the same task. Okay, like our electronic calculator. Now, if this is the input, then of course there is an output. So on the other hand, AI system learns the rules. Here I can say learns the functions through training data, whatever the input we are putting into the AI. AI has the potential to change healthcare by producing new and essential insights from the vast amount of digital data created during the healthcare delivery. So the data we are putting because of the previous experiences dealing with the previous patients. So AI is typically implemented as a system comprised of both software and hardware. So from software standpoint, AI is mainly concerned with the algorithm. So AI neutral network, which is known as ANN, is a conceptual framework for developing AI algorithm. So it's a human brain model made up of an interconnected network of neurons connected by weighted communication channels. Now, AI uses various algorithms to find complex non-linear correlations in massive data sets, machines learn by correcting minor algorithm errors, thereby boosting prediction and accuracy we are expecting. Now, this use of new technology raises concern about the possibility that is become a new source of inaccuracy and data breach. So in the high risk area of healthcare, mistakes can have severe consequences for the patient who is the victim of this error. This is critical to remember since patients come into contact, as I told, in a very vulnerable time. So this is the one basic problem in the AI in health sector. Okay. Now we are coming to the some of the applications in that. Now, let's say the drug development, how AI is now utilizing in the drug development. So AI is expected to simplify and accelerate pharmaceutical development. AI can convert drug discovery from a labor intensive to capital and the data intensive process by utilizing robotics and models of genetic targets, drugs, organs, disease, and their progression. So what happened? Pharmacokinetics, safety, and efficacy, artificial intelligence can be used in the drug discovery and development process to speed up and made it more cost effective and efficient because machine is doing that. Although, like any other drug study, identifying a lead molecule, okay, and guarantee the development of safe and successful therapy. That is the thing, because sometimes we know that one example is AI was used to identify potential Ebola virus medicine previously. Okay, so in this manner, and now we know that during the COVID also how we have struggled and we try to figure it out by the trial and error process, this medicine, that medicine. So in this manner, now the ethical challenges. So there is a continuous debate regarding whether AI fits within existing legal categories or whether a new category with its spatial features and implications should be developed. The application of AI in clinical practice has enormous promise to improve healthcare, but it also poses ethical issues that we must now address. Now, number one, informed consent to use data. So whatever data the healthcare system is accumulating, are they taking the consent to use that data? So informed consent to use that data. Safety and transparency. I'm coming to the transparency. Algorithm transparency is the biggest issue. You already taken a project, there is some proposed solution also they have told. I'm coming to that, but this is the another biggest problem with the AI, that is the transparency issue. Now, algorithm fairness and biases. So data privacy are all important factors to consider because we know that already is there. Now, whether AI system may be considered legal is not only a legal one, but also politically continuous one contention for us that, I mean, there is a storage and we are giving a machine to access to that particular storage to collect. Correct. So this is the, in this manner, the algorithm programmed and AI is functioning. So there is no, I mean, somehow the question related with privacy, safety, risk factor, So consent is where, so all these things are coming up. Now the policymakers needed to be ensured that the moral demanding situation raised by enforcing AI in healthcare settings, and it can be tackled very proactively. The limitation of algorithm transparency is a concern that has dominated most legal discussion on artificial intelligence. The rise of AI in high-risk situation has increased the requirement of accountable, equitable, and transparent AI design and governance. So the accessibility and comprehensibility of information are the two most important aspects of transparency. So information about the functionality of the algorithm is frequently, deliberately made difficult to obtain. So we are not really getting what is going on. So the thing is like that. This is the one biggest problem, ethical problem. So our capacity to trace culpability back to the maker or operator is allegedly threatened by the machines that can operate by unfixed rules, learn new pattern of behavior, and the thing is like that. Good lot of people are fascinating by the AI. It seems, see, the thing is like that. We dreamed about the supercomputer, correct? Now we are really thinking AI is a solution for good lot of things. AI is making life simpler. AI is doing very dynamic thing. So people are fascinating by the AI thing. But till now, AI is nothing but a algorithm or program made by the human being. They are not the replacement till now of the human being. So the thing is like that, and the decision making, what human brain can do, the decision making with the sensibility or sensitiveness, with our own intelligence, with the experience, what the human being can do. There is a till now question. We have not reached to that particular supercomputer stage where the human brain can be replaced by the technology. So it's a technology driven thing. And that technology is again made by the human. So somehow human error can be possible, and somehow they are not in that particular stage. Now, application in the research of health related research. So the use of created for electronic health records is an important field of AI-based health research. Such data may be difficult to use in the underlying information technology system, and database do not prevent the spread of heterogeneous or low quality data. So the segregation or what needed to be taken, that's is in the machine hand. So that's the one problem. Now, modern computing approaches can hide the thinking behind the output of an artificial intelligence system, making meaningful scrutiny impossible. Therefore, the technique through which the artificial intelligence system generates its outputs is opaque. It's not transparent. A procedure used by the AIS, artificial intelligence system, may be so sophisticated that for a non-technically trained clinical user, it is effectively concealed while remaining straightforward to understand for a techie skilled in that area of the computer science. So whoever is utilizing it, the nitty-gritties of the technicalities are not in hand. Think the country like India, or I mean, we are technologically very sound, but not all the people. Okay, so in this manner. Now, like IBM's Watson for oncology are meant to support clinical users and hence directly influence clinical decision making. Now, AIS would then evaluate the information and recommend the patient's care. The use of AI to assist clinicians in the future could change clinical decision making. And if it is adapted in this manner and create new stakeholder dynamics, the future scenario of employing AIS to help clinicians could, it could be revolution for the clinical decision making. Create a new healthcare paradigm even. Now, clinicians, including doctor, nurse, and other healthcare professionals have a stake in the safe roll out of new technologies in the clinical settings. But the thing is like that we cannot held label that particular machine. But the doctor, nurses, other healthcare members, pathologists, they are utilizing this particular AI system. And if the machine did the error and they cannot understand the nitty-gritties of the technology, they know their subject very well. And they're thinking that is a good guidance from the AI they are getting. So there is a clash. Okay, so the thing is like that. Now, researchers ought to describe how those outputs can be included in the research along with the prediction. The information is essential to setting up the cost of scientific trial and guiding scientific research. AI applied in healthcare needs to adjust to a continuously changing environment with frequent disruption, while maintaining these ethical principles to ensure the well-being of patients. However, an easy key component of figuring out the protection of any healthcare software relies upon the capacity to check out the software and recognize how the software would fail. That I was telling. They're pioneer in their medical field. They know their subject. Correct. Now we are expecting simultaneously they needed to be pioneer in both fields. That combination could be possible, but question is still not there. Okay. So for example, the additives and psychological mechanism of medication or medicinal device are comparable to the technique for software program. On the other hand, there is a one typical terminology we use, that is the black box issue. With working that aren't visible to the evaluator, doctors, or patients, researchers ought to describe how those outputs can be included in the research along with the prediction. This information helps access the cost of the scientific trial and guides scientific research. So this is the situation. Now I'm just telling you one typical story, the human psychological understanding or thing. My sister is doctor, and she's a gynecologist. It's a very funny story, but very effective story as well. So when the pregnant woman, they're not allowed to give the sedative to them. And because of the pain, it's just a huge pain they're suffering from. They want to sleep, they scream, and they asking for that. And plain and simple, as a doctor, they used to give the Digene. So they used to say, वो जो pink बड़ा वाला tablet है ना, वो दे दो, तुरंत नींद आ जाएंगे. So they used to give that. And believe me that the psychological understanding, they used to sleep because they think it is given by the doctor and by taking the Digen, they used to sleep. So you can understand that it's an experience. It's the human discretion, understanding the situation and dealing with all those things. So here, collecting data and data analysis, and when machine is deciding what to do, what not to do. So it's not the empathy or understanding of the human sense. Okay, so that's the one thing. Now the resolution, what European Parliament actually given, a research commissioned and supervised and published their policy, Department of Citizen Rights and Constitutional Affairs, in response to a request from the European Parliament's Committee on Legal Affairs. So the report emphasized the critical nature of a solution, a resolution calling for an immediate creation of a legislative instrument governing robots and AI, capable of anticipating and adapting to any scientific breakthrough anticipated in the medium term. So the various ethical and legal concerns associated with the use of AI in healthcare can be highlighted. Okay. Now, why responsibility is necessary? That could be the question. So when the setting or a context changes, AI system can fail unexpectedly, drastically. AI can go from being extremely intelligent to extremely naive is an infant. So that's the problem. Okay, so there is a prediction, but what could happen unpredictably, that is not settled down yet. So all the AI system in this manner provided access to specific and qualified individuals who are grouped around a common governance structure subject to certain conditions with a specific aim in mind. So there is required of deletion, leaving the option for examining raw and marks data allows, it's needed to be allowing the comparison of alternative methodology to help implementation and avoids biasly study output. So a greater emphasis on data governance with accountability gained by access and rational records. Ascertain if the model is learning from the most recent pattern in the health data. Okay, so the thing is like that, patients do not receive treatments and machine learning results do not reach the treating team in time to influence decision making or the trials evaluation. So to see if the model is feasible and if it can be used in clinical settings. So technical performance and calibration were evaluated using, that is the best practice actually. So by comparing quiet prediction to real-time patient labeling, evidence for the model clinical usefulness is obtained. So the thing is like that, sometimes it's case-to-case basis. People can have the allergy in certain medicine, and there is a need of requiring to treat one patient in a certain manner as per the requirement of that particular patient. So the AI generated data and the analysis is nothing but a collecting data, which is not discretely for particular one patient. Okay, so to see the model is more effective than the existing standard of treatment, then if we are looking for that, so till now we need to work on that particular model and we can reach to the goal. Okay, so the model was investigated in the context of its planned application in decision making. But I was telling, there is certain goal fixed and there is a planning, accordingly the software program done, and the decision making is based on that. It's not patient to patient, it's not situation to situation. So the outputs of the model were recorded. It's done already. It's not the instant decision making by the very knowledgeable, all the clinical persons. So the clinical decisions are kept track of. So we are continuously feeding data, and based on that, the AI is generating the decision. So determining the cause of a disparity in output and decision can be very rampant. Okay, so even if AI bias is managed, okay, so we have criticized AI a lot, the human decision maker must be aware of the system's limitation, and the system must be designed so that it fits the demands of the human decision maker. What I have earlier explained, that we have dreamed about that supercomputer, but we are not in that particular level till now. So whatever the fascinating words or fascinating now the technological development is going on, so we need to think once more. Okay, so all these aspects. So when a medical diagnostic and treatment system is mostly accurate, medical practitioners who use it may grow enormously, failing to maintain their skills or take pleasure in their work. Furthermore, people may accept decision support system results without questioning their limit. So totally depending on the AI without knowing the limits, it's questionable. This sort of failure will be repeated in other areas, such as analogy could be criminal justice system, where judges have modified their decision based on risk assessment and later revealed it is totally inaccurate. So the use of AI without human mediation raises concern about vulnerabilities in cybersecurity as well. Now, according to the RAND perspective, that is the European Union initiative perspective report applying AI for surveillance or cybersecurity in national security creates a new attack. Okay, so it's called actually the data diet vulnerabilities. The study also discussed domestic security issues such as government's employment of artificial agents for citizen surveillance. This have been highlighted as potential jeopardizing citizens' fundamental rights. So these are serious concern because they put key infrastructure at risk, putting lives and human security and resource access at risk. Cybersecurity weakness can be severe threat because they are typically hidden and only discovered after the damage caused. So in a recent year, there has been an uptick in the feasibility design, the ethics of lethal autonomous weapon system. These machines would have AI autonomous, vast discretion combined with the power to murder and inflict damage to humans while this advancement may offer considerably, disadvantageous position. So morality is the concern here again. So the thing is like that, come back to the healthcare. I've just given some analogy, how it can be devastating. So unlike doctors, technologists, and not obliged by the law to be accountable for their actions, instead, ethical principle of practice are applied in this particular sector because AI is doing. I'm just following the orders. Okay, so AI should be. Can it be? AI can be the accountable in the healthcare context, which directly affects the patients. So if a clinician can't account for the output of the AIs they are employing, they won't be able to appropriately justify their actions if they chose to use that data. This lack of accountability raises concern about the possible safety consequences of using unverified and unvalidated AIs in clinical settings. Okay, so this is the one typical thing. Now, we think that a new framework and approach is needed for approval of AI system, but practitioners and hospitals using it needed to be trained and hence have the ultimate responsibility of its use. That is needed. We can't say they are not responsible. Medical devices-based AI will facilitate the decision-making to carry out treatment and procedure by the individual and not to replace them entirely. It's not possible. Okay. So till now, there is a dearth of literature in this regard. And what type of detailed framework is needed or developed, policymaker needs to think about this particular thing. AI should be evaluated and validated, as I told earlier. So the access, taste, measure, dependability, their performance, safety, ethical compliance, robots and artificial intelligence system logically, statistically before they are implemented. There is a need. So there is a need of a very much in-depth primary practice run or trial or running the thing. Then in the practical life, we can use this particular thing. So in this manner, we can discuss the particular thing. Now, AI, as I told, AI and human rights issue already I have discussed from the point of view of the healthcare system. Now, one problem is the lack of algorithm transparency. I've already told that. It's the really, really problematic thing. Now, the lack of algorithm transparency is problematic. And Kroll actually in 2017, one write-up highlights why using examples of people who were denied jobs, refused loans, were put on fly list or denied benefits without knowing. Now, why it is happening? Now, the decision was processed through some software. So they're collecting data. So parameters are not matching. So there is no human discretion to assess the whole thing. And because of that, some negative impact to the humans or a negative decision is coming. Now, there are certain solution. The EU Parliament ST08 study outlined various policy options to govern algorithm transparency and accountability based on an analysis of the social, technical, and regulatory challenges Each options address a different aspect of algorithm transparency and accountability. Number one, awareness raising, education, watchdogs, whistleblowers. Second, accountability in public sector, use of algorithmic decision making. Third, regulatory oversight and legal liability. Fourth, global coordination for all algorithmic governance. More specific solution mooted to promote algorithmic transparency include algorithmic impact assessment. So algorithmic transparency standard. Okay, so that is the need. So transparency of autonomous system, counterfactual explanation, local interpretation, model explanation, that can be the thing. What are the challenges? Transparency has its limitation, we know that. So even when machine learning decisions can be explained, decision subjects may not agree with the outcome. So whatever the input, and we are expecting certain outputs, it is not matching simply after the analysis, after the machine learning, whatever the outcome we are getting. So some of solution proposed, we have already know about this. So algorithm impact assessment through extremely valuable are relatively new and still work in progress. So we cannot be fully evaluated for their effectiveness at the very moment. This is definitely an area for future research and evaluation. Another highlight of this particular issue and significance, that various security issues related with the AI. For example, fully automated decision making leading to costly errors and fatal situation. The use of AI weapons without human mediation, issues related with AI vulnerabilities in cybersecurity, how the applications of AI to surveillance or cybersecurity for national security opens a new attack vector based on data diet. I have already mentioned that. So in this manner, some sort of discrepancies are largely coming. So we know the use of network intervention method by foreign deployed AI and larger scale, more strategic version of to take the advancement in the political messages on social media. We know that. So the behavioral pattern, whatever we are commenting, our liking to the post, our comments or something like that, in this manner, they are collecting the data. We know Cambridge Analytica, what the situation happened through the Facebook. So the thing is like that, these have been called out for their potential to adversely impact fundamental citizen rights. Such issues are significantly as they lay open critical infrastructure to harms with severe impacts on society and individual. So posing a threat to life and human security and access to resources, cybersecurity vulnerabilities also pose a significant threat, as they are often not revealed only, we can get, or we can have the clear idea after the situation happened, after the damage happened. So in this manner, the situation can be very much devastated. So various strategies and tools are being used or proposed to address these issues already. Now, putting in place a good protection and recovery mechanism, considering and addressing vulnerabilities in the design process, engaging human analysis in critical decision making, using a risk management program and software updates, all these things we needed to be addressed meticulously. Now, effectively addressing such issues requires proactive and responsive use of cybersecurity policies and mechanism and tools by developers and users at all stages, design and implementation, that particular use. But often this cases in practice is really challenged. So theoretically, by text, whatever the solution today we are suggesting or we are addressing the issues, correct? But the suggestions we are or solution we are telling or what exactly needed to be done, most of the time whenever we are implementing, as I told earlier, that fascinating, catchy, and this AI driven, we are so much into it. Very recently, I think AI hype of fascinating world is quite a long years. Very recently, I think just the 1 year maybe or maybe less than that, we started giving the concern about the problems even. Okay, now we started talking about the ethical issue, moral issue, and this jeopardized situation. We started talking about the against human rights, the vulnerability, this complexity. Actually, we started talking right now. So primarily the AI and its fascinating world, and AI could have done each and everything. That particular dreamy world is somehow knocking our door. There is a need to think other way around as well. So when designing a system that use a machine's learning model, engineers should carefully consider their choice of a particular architecture based on understanding of potential attacks and on clear, reasonable trade-off decision between model complexity, explainability, and robustness. So that is the thing. So theoretically, it has been done, but practical implementation and practically doing all these things, then only we can come out from that particular understanding. So the EU agency for fundamental rights outlines the potential for discrimination against individuals via algorithm and states that the principle of non-discrimination and Charter of Fundamental Rights also somehow emphasis on that. It cites example with potential for discrimination, automated selection of candidates for job interview, use of risk scores in credit worthiness or in trials. So in this manner, the fundamental rights implication of big data, privacy, data protection, non-discrimination, security, law enforcement, all these coming now into the radar. Okay, so in this manner, do I have some time or should I stop? Hello? Hello? Am I audible?
Shalja,
Yes, ma'am, you're audible. Ma'am, you have 10 minutes. You can summarize.
Okay. Thank you so much. Okay. So the thing is like that. So this data processing or big data, because right now we started talking about the big data intervention and competition law perspective as well. It's ongoing that all the the market giants, online market giants like Amazon, Flipkart, and other, they are actually collecting data and who are very prominent. They are utilizing those big data. Competition law concern is also there. So anyway, the data processing and big data may result not only in the infringement of the fundamental rights of individual, but also it differential treatment, direct discrimination against group of people with similar characteristics, particularly with regard to the fairness and equality of opportunity for access to education, employment, when recruiting or assessing individuals, or when determining the new consumer habits of social and media users. Now, I'm just telling one good example from a job perspectives. Everyone can get that. Now, when we used to do the interview, we can see as a, as a certificate holder, on paper, there are so many things. But when we judging a candidate as a teacher, so maybe someone is not having that many certificate, but explaining the thing or the whatever the knowledge depth and the teaching capacity, answering capacity is exemplary in comparison to having a good lot of certificates and papers and this course and that course, all these things. Now, when AI is doing, it's based on some data. We are feeding this qualification, these records are there. So the decision making is that. So the equal opportunity for what is happened in the human discretion is not there. Okay, so this is the particular thing I just want to emphasize here. So some report actually told to identify and take any possible measures to minimize algorithm discrimination and bias, and to develop a strong and common ethical framework for the transparent processing of personal data and automated decision making that may guide data usage and ongoing enforcement of law. So in this manner, anyway, any solution we can propose, various proposals have been made to address those issues, as I have told. For example, conducting regular assessment into the representativeness of data set and whether they are affected by bias elements, making technological or algorithmic adjustment to compensate for problematic bias, humans in the loop, and making algorithm open, schemes to certify the algorithmic decision system do not exhibit unjustified bias are also being developed. Standard for all the algorithmic bias consideration is needed. So these are the, already in the discussion, global initiative on ethics of autonomous and AI systems. It aims to provide individuals or organization creating algorithm system with a development framework to avoid unintended, unjustified, inappropriate differential outcome for users. There are also open source toolkit. Example, AI Fairness 360 open source toolkit. That helps users to examine, report, and mitigate discrimination and bias in machine learning models throughout the AI application lifecycle. Okay, so in this manner, some are there. Now, while the law clearly regulates and protects against discriminatory behavior, it is suggested it falls short somehow. As I told, the law leaves shortfalls where it does not extend to address what is not expressly protected against discrimination by law. where new class of differential needed to be created to lead to the bias and discriminatory effects. So there are the gaps. I mean, we can talk about it, but now lack of contestability. So the individual rights to the challenge and request a review of automated decision making that significantly affect their rights or legitimate interest. Data subjects have the right to object on grounds relating to their particular situation at any time to processing of personal data concerning them, which is based on task carried out in public interest or legitimate interest. So even the GDPR, the European Data Protection Controller, I mean, they are also not having, for the data protection, we think that it could be a good model for the data protection. That also not having suitable measures to safeguard the data subjects' rights and freedoms to the legitimate interests of the people. So intellectual property issues also there. We know that the intellectual property rights are, data is part of it. So somehow AI raises various intellectual property rights issues. Who owns AI generated or produced works or invention? Should AI inventions be considered as a prior art? Who owns the data sets from which an artificial intelligence must learn? Who should be liable for creativity and innovation generated by the AI if they infringe others' right or other legal provisions? Who is the infringer? So this intellectual property problem is also there. Now, in the very much conclusion, so concludedly, I can say that artificial intelligence as simply math applied to the data. In a very simplistic one sentence language about the AI. What is AI? So when the data is your own, such as your own original writing, AI serves as a tool to modify what you have already done. However, using AI to modify others' people's work means ethical and legal issue of ownership, copyright. These things will come in a very simple language. So whenever you rely on technology to create content, you run the risk of having inaccurate data. Okay, so we have seen that in some examples, various authors also told that someone written one article and it is running through the GPT-0, a free tool that analyzes content and provides details for how much of the document is written by the AI. The result indicated, yes, it was likely written by AI. So the write-up is totally changed. So we know that we are a social science people. So idea is maybe the same, but the approach or expression is totally different. So the unity and diversity of India is the topic. Then I am writing in a satire manner, or someone is writing from a historical perspective. Some informations are common: heterogeneous diversity, heterogeneous people, vast population, good lot of, so some informations are common. But this particular perspective one writer is having. So whenever you are running to the GPT-0 or any other this type of tool, free tool that analyze the content, now it's a AI written thing, not that human written thing. Okay, one example I can include here, that one article, I got that somewhere whenever I read that marketing in the age of pervasive media by David Meerman, Scott, and Brian. So what happened? The thing is like that after analyzing that particular content, when the output came, the writer told, it's not my book. It's not my title. Clearly the AI messed up and the author of the article, I mean, it's not really checked the accuracy or not. I mean, sometimes I have a problem. I mean, maybe people are not really agreeing with me that our Turnitin software. Okay, so it is feeded data, correct? Depository is there and they are judging the similarity index based on that. So the thing is like that. Now I have to give, whenever I'm writing, suppose I'm writing based on the act, analysis of Biodiversity Act. And of course, I'm giving the sections because section is very much needed because I'm criticizing those provisions. Now, those sections are coming under the similarity index because the depository is having that particular act. Similarity index is increasing. Now, we are keeping the bar as per the percentage. We are always seeing what? 10%, 20%. We are not seeing anytime, even with the teachers, never seen, never judge from the human discretion what is actually the write-up. How the similarity index is actually reflecting that. So these are the things, very simple example. In our day-to-day life, each and every one of us actually face this particular thing. So when AI is using data on the public web, it is using others people work to generate content. And sometimes, I mean, this is the very first time I came to know, I really didn't know. One of my junior colleague actually told me, ma'am, there is a paraphrasing tool. Hello, eh? Okay. So this is the first time I came to know after so many years experience that there is a paraphrasing tool. And when this paraphrasing tool actually worked, I mean, it's very funny to look into it. There is no grammar. I mean, the construction of sentence is totally meaningless. And it's very easily to figure it out that something had happened. Whoever know is a very little English also, they don't do this type of mistake. So the thing is like that. This is the, I mean, problematic thing. Now, even ChatGPT, newsjacking, it's a marketing strategy in which a company or brand tries to align itself with a current news events or trending topic in order to capture public attention and promotes its products or services. The goal is to insert the brand into the conversation surrounding the news event, thereby increasing its visibility and relevance. So this can be done through various means such as social media, post, advertisement, blog articles, and more. Now, the key to successful newsjacking is to be quick, relevant, and it is not coming into the similarity radar also. It's not a plagiarism as such, no. But you can smell someone has taken your words. You know your writing style. Each and every author is having their own writing style. So in this manner, we can see the typical problem. Now the problem is the human authorship is the problem here. Attribution of a creative work to a natural person as a creator or originator. When human creates a work, it's clear who is the author. But in the AI system, create something, who should be considered as the author? Okay. because it's actually the result of the collecting data and data analysis. So originality is the questions. Fair use is the questions. So in this manner, these are the things we can say. So I'm stopping here, and now I am opening for the, I'm opening for the questions. I don't know how much I am understandable.
A lot. Thank you. There we had Dr. Gargi Chakravarti. Ma'am is holding currently an academic and research position. She has been teaching at NLU Jodhpur. Ma'am, a very rich, detailed exposition in this technical session of, as our area theme today is emerging concepts in artificial intelligence and the impact of artificial intelligence on the healthcare, right? And how the healthcare is dealing with artificial intelligence, how we humans can, benefit the masses, the people all over India and internationally can benefit from the usage of artificial intelligence. And then what are the effect of the artificial intelligence on the healthcare and people, and then intellectual property right and various other related ancillary issues you have raised, copyright and writing, and the various lacunas that there are, we are having, like you pointed out at one stream that the literature is still, there is a paucity, there is still a dearth we are facing in the literature, and the students are researching and referencing. Ma'am, we have one question from Momina Jahan. She is raising this thing that she's asking from you, that how the artificial intelligence data which is generated in the healthcare is protected, how the data is protected by the artificial intelligence in the healthcare industry.
No, actually, I'm telling you very, I mean, a bit controversial, but we know that data protection in India is a very questionable thing till now, because it's pending for a quite long time. Only the Information Technology Act is having some sort of concern for the data. And India is not very much concerned about, it's our typical understanding. I'm just giving one typical example. When I was in Max Planck, there was a conference, and I just take out my mobile, and one of my colleague ran to me and told me, Gargi, don't take pictures before asking. So in India, we never think that privacy is like that. We are not allowed to take the pictures even of a person without asking. So I used to give nowadays this practical experience to my student as well. So in this manner, we are not such, concerned. I'm telling you one typical thing, so you can well understand that. Whenever after having, we know the cookies breach and all those datas, so your mobile number is circulated to the n number of companies, and n number of companies for various reasons are calling you, unnecessarily junk call you are receiving for the promotion purpose. So from where you are getting my name and my number? That is the question. So it's a privacy breach. So data retention, how long you need to return the data, how you are utilizing the data, this clarity in the commercial level is not really in India very good manner. So the each and every hospitals or each and every companies, whoever is collecting the data, how it is utilizing those things, it's questionable. Data protection is really questionable. And based on those datas, actually, there is a software program, and I'm actually filling the data in that particular program. That program is analyzing and giving me certain output, means giving me certain direction or certain prediction, what to do, what not to do. That is the thing. In a very simplest language, this is the thing.
Ma'am,
So data protection is on questions.
Miss Kirti Goyal is asking that are there possibilities? Is it currently taking place, or there is a possibility in the future that artificial intelligence could be utilized in the justice delivery system in India?
I told, see, the human discretion, I have mentioned that human discretion, the analyzing the, I mean, good lot of things actually, whenever the judgment is coming, they decide. Correct. Now, I mean, it's an intellectual property and I'm an IP person as well. I'm just telling. So there is a 2 mark. One typical example I'm giving, 2 mark. Now I have decided, seeing that a 2 mark is very likelihood of confusion is there. So it's an infringement. That could be the one case. And now analyzing the each and every possible thing, that prior use is there, when they applied, the consumer perception, concurrent use can be possible. There are so many things. So infringement is a one typical 1-line sentence and that's it. But evaluating the whole thing and then reaching to the decision, I think we need to wait to AI to reach in the human minds, and they are in the position to analyze all the things in this manner as per the situation, case to case basis.
So basically, you are saying that the conclusion is that we are in the systemic age. You know, it is evolving.
Correct. We are
And
in
we
a
as humans
developing
are also
stage.
evolving to understand it.
Yeah. So I usually do, one of my PhD student, assistant professor at NLU Jodhpur, he is doing the research on the AI. He was overexcited when he started that particular AI. So the thing is like that. I have given that the one symphony of Mozart is completed by the AI, which is not completed by the Mozart. And he was fascinated by that. Ma'am, AI did that. And I'm, come on, man, AI did, that is why it is correct. If it is a human doing, obviously the improvisation and their skill, I mean, something will come up. So whenever you have put as a data all the symphonies of Mozart as a data, so they are analyzing, they accurately collect that particular thing and completed that last symphony, which is not completed yet. So it could be possible. So if any human being, the human touch will come. So there is no possibility of that. So it's at a developing stage. Don't jump into it. AI is doing the robusting thing in this manner. Okay, so it's in a developing stage. Obviously, there are good lot of positive effects, but till there are good lot of negative effects. I mean, I think it's my basic understanding. See, whenever anything good is happening, that is good for us. But we have to prepare for whatever the bad will come. So we have to know the bad and we have to mitigate in this manner. So that's we are in the developing stage.
Thank you, ma'am. Thank you, Gargi ma'am. Very rich and profound detailed study on AI and various multiple faceted issues on that. Over to you, Richa ma'am.
Richa, you are mute.
You're mute.
Thank you, ma'am. At times we forget that we are on an online platform and we need to, unmute ourselves. Ma'am, I have been a big fan of yours. I said the same thing when I attended your last webinar, especially in. I always look forward to what you write and to what you say. That being my favorite subject, that's been the reason. And today also it had been wonderful to listen to your discourse. AI, we all know, there's so much of contention over AI. It is being said that it is disrupting our lives. At the same time, it is making our lives easy as well. But the way you explained it, I'm very sure the student must have gained something, and they must have got the masala to think over that what that what AI is and how AI is impacting us in our different facets of life. So thank you so very much, ma'am. It is always a pleasure to listen to you, and we hope to keep listening to you on various platforms. Ma'am, now you are on mute.
So now I am on mute. Yes, thank you so much for the invitation. It's my pleasure and love to share whatever I have gathered. I'm still learning lot. So I just shared my whatever I gathered. Thank you so much.
Thank you,
Thank
ma'am. Ma'am, I would like to also thank on behalf of Alaknanda. She is not able to
Yes, I
join.
know. We have interacted. It's a very sad news. Yeah.
Yes, ma'am. So thank you so very much, ma'am, for accepting our invitation and gracing us with your presence.
One thing, Richa, can I leave now?
Yes, ma'am. Yes, ma'am. Please,
Okay.
I know.
Thank you so much.
Yes, yes. Thank you so very much, ma'am. Shelja ma'am, I think Ruchika ma'am also joined some time back.
Ma'am has been joining.
Yes. Ruchika ma'am, are you there?
I'm here.
A very good afternoon, ma'am.
Good afternoon, Ruchika ma'am.
Good afternoon. How are you doing?
Very well, ma'am. Thank you so very much for being here. Ma'am, if you may allow, can we proceed with the session at 2:10 as
Yeah, sure. I thought it was supposed to start at 2:10. I just joined earlier.
Oh no, that's very, very nice of you. It is always nice to have the speakers when they listen to each other's discourse. It is, much more enriching for themselves, and when they, deliver their session, then also it becomes very nice for the participants to relate with what the two speakers has said. So, ma'am, we will resume at 2:10 sharp, and
Okay.
okay, thank you so much, ma'am. So the participants, you have 15 minutes time to take a break, and we'll quickly return back at 2:10 with the next technical session of ours. Yes, Shelja ma'am?
Anji, ma'am. Yes, ma'am. Thank you,
Please
Richa ma'am.
do not log out. You can just, put it on pause, and then you can resume again.
Yes. Thank you so much, Richa ma'am.
Okay, thank you, ma'am.
A very warm and heartiest good afternoon on behalf of Amity Law School, Amity University, Noida. Thank you so much, Ruchika ma'am, as our next resource person. Ma'am has been very much illuminating at the academic and legal scholarship. Ma'am is also a professor at National University Sciences, West Bengal. She is also holding a legal position at Ketan and Company. Ma'am has a very highlighting career in intellectual property rights, which also justifies our theme for this upcoming ongoing week as a part of Mulya Prabha Value Added Edition. Ruchika ma'am holds LLM, a Master's in Law from University College London, and now she's there today with us on writing more with the profound knowledge on intellectual property rights. Thank you, Ruchika ma'am.
Thank you, Shelja. Thank you, Richa. Thank you for having me today. I will be dealing basically with the aspects of trademark. So I will not as such be dealing with the other aspects of copyright or patents. So I will be focusing primarily on the aspects of trademark and how artificial intelligence has impacted the trademark law in India. Now, if anybody has any questions, please feel free to interrupt, and it does not necessarily have to be a question. It can be any thought you have or anything that you actually faced while working or while writing anything, and I'll try to address them. Now, what is artificial intelligence? Now, the term artificial intelligence was first coined way back in 1956. That's more than 60 years back by John McCarthy. I think you've all heard on the landmark book McCarthy on Trademarks, which we've all referred to at some point of time in our legal careers. So in way back, 60 years back, he actually coined the term on artificial intelligence. And what he meant with this concept was artificial intelligence is basically a concept which is a thinking machine. So it's a machine which can think on its own. Now, if it's a machine which can think on its own, how is it going to affect intellectual property laws? Because at the end of the day, whenever we are talking about intellectual property laws, we are trying to reward innovation in some way or the other. Whenever you invent something, you are trying to protect that. As we say in copyright law, whatever is worth copying is also worth protecting. In trademark, you're trying to protect a brand. So now, how is artificial intelligence going to affect this? Now, when it comes to trademark, what is the standard that we use for trademark protection? It is very different from what we use for copyright or patents. Does anybody have any views on, or does anybody know what is the standard of protection that is granted for trademark law? When we try to say that one brand is similar to another, what is the standard that we use in this case? Okay, I'll just explain. When it comes to trademark law, when we say that one brand is similar to another, or when we say that two brands are deceptively similar, there is a likelihood of confusion between two brands. The standard in this case is an ordinary common man. It is not an expert in the field. It is what an ordinary common man on the street with very common intelligence finds to be deceptively similar that we have to take as the standard. Whenever we call witnesses to court for trading to find out if two marks are deceptively similar, we cannot call an expert witness to court, at least for trademarks. The standard is exactly the opposite for patents. For patents, you actually have to call upon experts. In case of trademarks, you have to call upon an average common man with average intelligence. So if that person says that two marks are deceptively similar, then the court will always hold that the two marks are deceptively similar. In this case, you cannot call somebody who's very brand conscious to court. For example, the Chanel brand, of course, all of you must have heard of the Chanel brand. It's two interlocking C's which form the Chanel brand. Now, when we are talking about that, all of us, so a very brand conscious person will know that when two C's are interlocking, it is the Chanel brand. But what if there are two C's which are just touching each other and not interlocking? Somebody who's very brand conscious will know that this is not a real Chanel brand, this is a fake Chanel brand. But somebody who's a person on the street will not be able to differentiate between two interlocking C's and two C's touching each other. So in that case, there is definitely a likelihood of confusion. Now, when artificial intelligence comes in, this is the point where we have to determine, the courts have to determine whether artificial intelligence is a real person or is it an artificial person. Now, if any of you have an idea about how trademarks are registered, when it comes to trademark prosecution, the first step in the process of registering a trademark is that we have to search for marks which are deceptively similar or which can cause confusion in the minds of the public. Now, whenever you're searching for marks, the trademark registry uses a system of artificial intelligence to see if two marks are similar to each other. So this is where artificial intelligence comes in. The trademark search is not done by an actual person. You give in some strings or some keywords, and on the basis of that, the registry basically generates your search. Now, what are the ways in which marks can be deceptively similar? Loyalty? You mean brand loyalty?
Ma'am, the students, they cannot unmute themselves, but the
Oh.
participants, you can put that in the chat box. Your comments can be read through the chat box.
Okay, thank you. Yes, Tisha, you're right. It's done on the basis of categories and classes. So whichever class you're searching for and whichever category or trademark you're searching for, it is exactly done in that class. You're actually very right. So suppose you're searching in class 5, which is the class for medicines. So in that case, you have to put in a string. Suppose your string is Crocin. So there are 3 ways in which searches can be done. One is obviously phonetic similarity. One is the search similarity. And one is obviously whether 2 words, the marks are actually visually similar. Again, this is where AI comes in. When you are calling a common person, you can actually judge whether a mark is deceptively similar or not. But can AI actually determine whether 2 marks are deceptively similar or not based on the phonetic similarity or the visual similarity? So this is a question which courts have not yet addressed, but this is a question which in the next 2 to 5 years is definitely going to come up before courts, and how these things are going to be addressed, because it can be, that's the thing. How is artificial intelligence going to judge whether 2 marks are deceptively similar or not? And what if artificial intelligence is wrong? At the end of the day, it's not a person, it's a machine. The machine can think, but I mean, how right is the machine? And at the end of the day, somebody has programmed the machine. So the machine is not really thinking on its own. It's on the basis of whoever has programmed the machine has put it in. So if the machine is not thinking in a right way, in that case, what is the remedy available to the person who actually owns the brand? So these are the questions which will come up in trademark law. Now, another very important case is the case of online shopping. Now, when it comes to online shopping, all of us shop on Amazon, Flipkart, and any other platform that any of you might be use. It can be eBay, it can be anything. Now, the thing is, if you have noticed, whenever you shop for something, or whenever you even search for any product on Amazon, you don't even have to actually buy it. The next time you go to Amazon, you will notice that you are being shown similar products based on whatever you searched for earlier or whatever you purchased earlier. Now, in this case, who is doing this? Is this an actual person who is showing you similar products on the basis that you might be interested in buying those products? Or is it artificial intelligence? Yeah, exactly. This is where artificial intelligence is coming in. So, and this is where the importance of artificial intelligence in case of trademarks are coming in. So if AI is basically showing you brands on the basis of whatever your initial interest was, here the question is Amazon guilty of secondary infringement? Is it possible that Amazon is actually infringing your mark? Because whenever you search for certain products, Amazon, based on their artificial intelligence software, is directing you to another product. Do you think this is a case where you can say that there is infringement of a trademark by AI? It's not Amazon which is actually doing it. It's the AI which is fed into Amazon, which is basically directing you to another product. It can actually be a rival product. So if somebody else is diverting you to a rival product, is that a case of secondary infringement? There was a very interesting case a few years back. Some of you might have heard of it. It is called ConsimInfo versus Google. So it is a case on Bharat Matrimony. So basically, whenever you searched for the term Bharat matrimony, instead of being directed to the right website, Google was somehow directing you to other websites which were not related to Bharat matrimony. And later, obviously, the court held that Google was guilty of secondary infringement because they were directing the traffic to other websites which were not exactly Bharat matrimony, and they were using Bharat matrimony's mark. Bharat matrimony is a registered trademark. And now this registered trademark was being used to direct the traffic to other websites, which is not Bharat matrimony. Now, if Amazon is doing the same thing, suppose you want to buy, say, a Dell laptop, but Amazon is diverting you to some other infringing laptop site or some other infringing laptop product. In that case, do you think Amazon is also guilty of secondary infringement? Vishwajit, two-step verification, how do you propose to introduce two-step verification? Human plus artificial intelligence. Okay, that's a good answer. That can be a step forward in future, that you also probably put in a sales assistant there who will ensure that users are not being directed to the wrong website. It is not just Amazon directing you to the wrong website. Amazon in cases don't even verify whether the product is genuine or not. It's not just trademark. What if they direct you to a product which is a counterfeit product in that case? In that case, do you think you can hold Amazon guilty? It's not even a genuine product. Forget about it being a infringing product or a rival product. Tisha, it is an infringement of privacy, but here we are not really discussing privacy. It is outside the scope of this discussion. We are just going to focus on IP laws here and trademark, basically. Privacy is a different ball game altogether. If Dell is not available on Amazon, then it's an infringement and violation of competitiveness. It is definitely secondary infringement. It is very similar to the ConsimInfo case. Whenever you direct traffic to other websites or other products, then it is secondary infringement. It is not a direct infringement because Amazon is not directly selling an infringing product of Dell. So instead of Dell, Amazon is not directing you to buy a laptop, which is say DEL, deal or something of that sort, but it is definitely secondary infringement. They are directing you to other products. And it is definitely also a violation of competition law. There was recently an antitrust case by the EU, where it was a case of Lush. So in that case, what happened is, in case of Lush, what happened was, whenever you search for Lush, then what happened was Amazon was, even if you search for it on Google, it would direct you to Amazon to buy Lush products. And then they said that this is also secondary infringement. Yes, they can be sued for secondary infringement. You can go to court and say that, this is secondary infringement. But in this case, the problem is the issue which is cropping up before the courts right now. In fact, there is a matter which is going on in Calcutta High Court, and the matter is sub judice, which is why I can't take the name of the case right now till a decision actually comes out. The point is, they can be sued for secondary infringement, but in this case, who is the party? Because Amazon is definitely not the party. Amazon is not directly infringing. It's the AI of Amazon which is infringing these marks. So can you sue AI as a party? This is the question which is actually the moot point over here. Who do you make the party? The company who programmed this artificial intelligence. Amazon is definitely a party, but Amazon is directly not infringing, which is the point here, where Amazon, like all the people who have like these websites, they all went to court and said, we are not directly infringing. We are not selling. We are not the person who is actually selling that laptop. So how can we be made a party? It's somebody else who is using that platform to sell it. Yes, the AI is made by Amazon, or at least commissioned by Amazon. It is the AI software companies, whoever probably commissioned that AI and authorized that person of using that AI who can be addressed in this case. You know about Amazon Echo, right? If you have followed the news, Amazon Echo can not only search for products, the person Amazon Echo can also order products on your behalf. There was a hilarious case in the US where a 5-year-old kid, it was just a baby almost, ordered products using Amazon Echo. Somehow the credit card of the mother was linked to the Amazon account, and that person managed to order toy using Amazon Echo. Now, in this case, if somebody is using an AI assistant or a AI chat box or something of that sort, in that case, do you think this can come under credit card fraud? Because at the end of the day, it was not really the kid who ordered it, it was Amazon Echo. Shubhangshi, to answer your question, Amazon is a company. It is definitely an artificial person. So Amazon can be sued, but the point over here is Amazon is not directly infringing. Amazon can be a secondary infringer, but Amazon is definitely not directly infringing. Mudit, that's a very good answer, that Amazon is acting as an intermediary. So in that case, the point is, the question of intermediary liability comes in. And we all know that intermediaries can be held liable in case of copyright or trademark infringement. So in that case, the point is, yes, you can hold Amazon liable saying that they are an intermediary, even if they did not directly infringe. That's a very good answer. If you can bring in intermediary liability, that's a very good route of actually suing Amazon through that way. Ayushi, no one starts using my trademark. Ayushi, there is actually no way that you can ensure that no one starts using your trademark. This is like asking a question that how do I ensure that nobody ever commits a crime? How do I ensure that nobody steals my money or nobody murders somebody? You can't ensure that. But once you find that somebody is using your trademark, then you can definitely take action against that person. But there's no foolproof system in the world to stop somebody from directly using your trademark. If you have registered your mark, then you have the right to take action against that person under the grounds of infringement. And the thing is, if you have not registered your mark, even then you have the right to protect your brand under the common law right of passing off. Passing off is recognized in India. So even if you have not registered your mark, but your mark is well known in the market, users associate your mark only with you, then you can definitely go to court and say that XYZ person is passing off their products as mine, and I have the common law right of passing off, and that person should stop using the product immediately. And if you can prove that your mark is well known in the market, then the court will immediately give an order of injunction against that person, and that person will be stopped from using that mark as soon as the court order is passed. Tisha, yes, you can file trademarks on your own theoretically, but practically speaking, it's always best to get the help of a lawyer or a professional, because they know the legalities that go on with it. So it's best if you actually use a lawyer. But no, theoretically, there is actually no need to use a lawyer. You can file on your own. When your mark has the R logo, then your mark is already registered. There is nothing called just registered. When you are using the small TM mark within the circle, that means you applied for a trademark. Applied for a trademark means that in that case, you've just applied for a trademark, your mark is pending. It can be granted. There is also a possibility that it might not be granted. But once you've got the R, that means your mark is already registered. In that case, you have the right of infringement against anybody who starts using your mark. In case of secondary infringement, the first remedy that you can get is injunction. You can stop the person who's the secondary infringer from infringing your mark as soon as the order is passed. So in that case, as soon as the order is passed, the person will be served with a copy of the order of the court, and that person will have to stop using that, that mode of infringement. So suppose Amazon, they prove that Amazon is secondarily infringing your mark. In that case, a court order will immediately be passed, and Amazon can no longer direct the traffic to those products. They will be stopped from doing it. They have to come up with a program which will not direct the traffic to that mark. So that's the first remedy, that's injunction. Second is damages. So if you can prove that you've suffered monetary damages, and this has to be proved through actual statistics as to how much damages you suffered, then in that case, what happens is the court might decide to give you some relief in case of the amount of losses you have suffered. And the third remedy is obviously up to the court. If the court thinks that you also need any other remedy, it's up to the court to come up with some relief. But the two most important ones is obviously injunction and damages. Okay, Tisha, do you know the process of registration of trademark? Okay, if you know the process of registration of trademark, there is a chance that a trademark might not be granted. There are various reasons for that. It can be that a deceptively similar trademark already exists on the registry website. In that case, your trademark will not be granted. So that is what the Register of Trademarks has to check. Under Section 11 of the Trademark Act, they will check whether a deceptively similar trademark already exists. In that case, your trademark might not be granted. And the thing is, after you apply for a trademark and the Register of Trademark thinks that it can be advertised before acceptance, okay? Advertised before acceptance, this is a stage. After that, it's open to opposition from the general public. So anybody in the general public who has a similar mark might oppose your mark. And if the opposition proceedings succeed, then your mark will not be granted. So there is, whenever you apply for a trademark, there is a chance that your mark might not be granted. 50% chance it will be granted, 50% chance it might not be granted. It depends on a case-to-case basis. Tisha, did that answer your question? No, the R logo, you will not get it. R logo is only after the trademark is granted. If the trademark is not granted, it will be a TM logo within the small sign. What generally happens is, I'll tell you from practical experience. When you've applied for a trademark, the first step is the registrar of trademarks will examine the mark and check it under section 9 and section 11. Do you know what section 9 and section 11 of the Trademark Act is? Yes, ITC versus Nestle. There is a chance that the mark might not be granted. Under section 9, they will see whether your mark, section 9 is absolute grounds of refusal. Section 11 is relative grounds of refusal. So if your trademark is not a very good mark, then it will be rejected under section 9. And if it's a mark which is similar to other marks on the registry website, then it can be rejected under section 11. And after that, obviously, like if you clear both 9 and 11, then it's advertised before acceptance. But even in that case, there might be opposition proceedings. No, the R logo will not be there. R logo is only after the mark has been granted. And during the opposition proceedings, you have to adduce evidence as to why your mark should be granted. So if you adduce enough evidence, only then your mark is granted. Otherwise, it's generally not granted, actually. What are the kinds of marks which are generally not granted? What should your mark not be? Generally, a mark is not granted if it's a descriptive mark. No, not offensive. Offensive is a different issue altogether. If your mark is offensive under the Constitution, like if you're using the national emblems or the national logos in a offensive manner, that's different. That's a criminal offense. If it's simply descriptive, then it will violate Section 9 of the Trademark Act. So, sir, what is a descriptive mark? Yes, religion-based can be also offensive. In that case, it's not granted, but that is basically a crime. It's not really a civil matter. Generic marks are not granted. For example, Xerox. Xerox is actually a trademark, was actually a trademark. Now it became so generic, it became part of the common parlance. Now we don't say photocopying anymore. We just say we are going to Xerox these papers. So if something becomes as generic as that it becomes a part of the user in general language, then it can't be registered as a trademark anymore. Another very interesting mark, which also became generic, is the Hawaii chappal. So Hawaii was actually Bata's trademark. Bata never bothered to actually protect the mark. And now the point is, Khadim went and tried to register it. Only then Bata woke up and said, hello, this is our trademark. But then the court said that it's become generic. We don't even like use it as a mark. We just say Hawaii chappal. So in that case, what happens is if a mark becomes so generic, then you lose the right over that trademark. It becomes a part of the common language. Udita, if only trademark is written in the product, then that mark has not yet been granted. So in that case, if there is another person in the market who's actually using the mark from an earlier day, then that person can be allowed to use that mark. Maggie has no longer is still a trademark. It's actually not become generic but yes, the way we are using Maggie, it will most likely be generic to mean noodles in a few years. It won't mean anything else. But as of now, it's still a trademark. So when you've only written TM in the product, that means that you only applied for the mark. There can be other users in the market who actually own that brand, so they can use that mark. Fevicol is still a mark. Fevicol is not a generic name as of now. What do you think is deceptively similar? Can you think of two marks which are deceptively similar? Have you heard of the Starbucks and Sardarbucks case? Yes, Dalda is generic. There was actually a case which held that, yes, Dalda has become a generic mark. Two marks are same, but the abbreviations are different, then it can still be infringement. There is nothing which says that two marks cannot be infringement. It can still be infringement. Just 1 second, let me share a site, then you'll understand better. Okay, I'm not being able to share my screen, but it's okay. I'll explain things. Whenever you're applying for a mark, if you can just write this down, ideally a mark should be fanciful. Now, when I say a mark should be fanciful, what it means in this case is that the mark should not describe the product in any way. So if you can show that a mark is fanciful, it will immediately get registered. Now, when is a mark fanciful? For example, Chrome as a browser is a very fanciful mark. When you say Chrome, it does not in any way describe what it's referring to. Another thing is, the next point is, the second point, the second level of distinctiveness is if a mark is arbitrary. Now, what do we mean by a mark being arbitrary? A mark is arbitrary, for example, Apple for computers. That is an arbitrary mark. When you think of Apple, you'll think of some Apple-based product. So, but Apple for computers is a very good mark because it's arbitrary. It does not describe the product in question in any way. The third is a suggestive mark. For example, Fair and Lovely. Of course, Fair and Lovely is banned now. It's just, but anyway, it suggests what the product is. A kind of a cream which will probably make you fairer and lovelier. So that's a suggestive mark. That's not supposed to be a very good mark. The moment a mark is suggestive, the Register of Trademarks can object under Section 9. And the fourth ground is when a mark is descriptive. So most marks, unfortunately, are descriptive. Descriptive marks are not supposed to be allowed, but unfortunately, most marks are descriptive. Burger King is a descriptive mark. Tisha, it describes what a burger is. I mean, the king of burgers, so Burger King, that's a descriptive mark. And generic marks are mark on which you won't get protection in any way. Yeah, camel in connection with cigarettes are arbitrary marks. Whenever you think of camel, you won't associate it with cigarettes. So that's a very good arbitrary mark. Bonvita, they are very this thing about protecting Bonvita. So I don't think Bonvita will ever become generic. Horlicks versus Complan, they are always cases every single day. These marks will not be generic. They are always protecting these marks. So every day, Horlicks is filing a case against Complan and Complan is filing a case against Horlicks. Yeah, paracetamol used to be a brand, but it's now become a generic term. You no longer call the medicine by its brand, you just call it paracetamol. Haldiram is not a descriptive mark. Haldiram is that person's name. So whenever a person's name is a mark, you can use it. So for example, if Devendra, your name is Devendra. Suppose today you have a mark called Devendra something, you can use it. So that is not a descriptive mark. The main problem which comes over here in case of trademark and artificial intelligence is when it's a real person, they can always say whether something is confusing or not. For example, you can say this Adidas and Abibus are definitely confusing. Do you think AI will be able to answer this question as to whether Adidas and Abibus is confusing? There was also a very funny case. Starbucks versus Sardar Baksh. It happened in Delhi. A person called Sardar Baksh opened a coffee shop with the name Sardar Baksh. And it had the picture of a Sardar in a green getup, which was very similar to the Starbucks mark. It's not phonetically similar because Starbucks and Sardar Baksh is different, but the mark is visually very similar. Now, if it goes to code, do you think artificial intelligence can be asked as to whether Starbucks and Sardar Baksh is similar and whether artificial intelligence should be allowed to judge that? These are issues which are going to be important in the next 4 or 5 years. No, Bikaner Wala is not generic. Marks generally don't become generic. I mean, even if they are well-known marks. Well-known marks are marks which are very well-known in the world in general or well-known in a particular area. So India has a registry of well-known marks. So if a mark is generally well-known, it does not mean that the mark is generic. For example, say MacBook or Mac is a well-known mark. It does not mean that the mark has become generic. Repeat points for difference between generic. Okay, sure. Karanpreet, generic marks are marks which have become so part of the common parlance that they can no longer be registered as trademarks. So suppose you are using a word as a part of the common language, then it can't be a trademark anymore. As I gave those examples, Horlicks, Xerox, Hawaii, these have become a part of the English language. Now they can no longer be registered as trademarks. Whereas general trademarks are anything which are still a brand. So for example, under section 9, if you read section 9 of the Trademarks Act, anything which is non-distinct should not be registered as a mark. I'm emphasizing on the word not. Section 9 says so. But suppose today you are a company, you're a startup. Would you really want a brand which is not descriptive? You won't. You would want a brand which describes your business in some way or the other. Shadi.com. It obviously suggests the kind of product that the website is offering, but it's still a registered mark. Ideally, it should not be registered, but the thing is, even if it is descriptive or suggestive in some case, if we had acquired distinctiveness, then it can be registered as a trademark. So if you want a mark to be registered, ideally, it should not be something which is descriptive. But the thing is, if you have a descriptive mark, but it has become distinct by way of use, then you can still register it. Yeah, Arpita, when a registered trademark becomes generic, if the court declares the mark to have become generic, then it ceases to be registered anymore. Then you can't get the benefits of registration anymore. So once a mark becomes generic, you can't register it anymore. The court will say that this mark has become generic and ask for it to be struck off the register. The same applies for well-known trademarks. When it comes to well-known trademarks, you have to apply to the court to get your trademark registered as a well-known trademark. What are the advantages of having your trademark registered as a well-known mark? If you have any idea of trademark law, you will probably know the answer to this. Okay, so this is the point. Whenever you register a trademark, you only get protection in the class in which it is registered. So for example, if Mango is registered for clothes, Mango will get protection only for any kind of clothes which is infringing the Mango mark. Now, Mango cannot get protection if today Mango launches laptops. So for example, Apple has laptops. Now Mango also decides to come up with laptops. Since Mango is not registered for laptops, Mango will not get protection for laptops. But the thing is, here is the catch. If you get your mark registered as a well-known trademark, then you will get protection across all classes. So suppose today Mango goes to court or goes to the registry and applies as a well-known trademark, and the registry grants Mango that, okay, yes, Mango is a well-known trademark. In that case, Mango will also get protection across all classes. So tomorrow, if they launch laptops, the Mango laptops will automatically be protected. Their protection will not just extend to clothes, but also to laptops. A well-known trademark is granted on the basis of how, as Vishwajit said, yeah, he's already answered the question, how its presence and how well-known it is known in the market in general. For example, Mercedes is a well-known brand. So Mercedes is obviously a car brand, but since it is a well-known trademark, you can't have Mercedes laptops unless Mercedes, the company itself, is diversing into the laptop business. That is different. Only the company itself can do it. You can't say, okay, I'm now going to use the Merck mark for laptops. Why will you object to Bikanerwala under section 9, subsection 2? Confusion of origin is obviously a ground of confusion under trademark law, but how is Bikanerwala creating confusion of origin? Under 9.2, you can object under a lot of points. It's basically under origin, but it can be any other points also. Amit, if you search the trademark registry, you will find lots of Bikanirwala registered, by the way. One day, if you're really interested in trademark law, you should probably search for it. Yeah, Elon Musk has different companies registered for different businesses. So whenever he's manufacturing cars under a different business, he's obviously bought Twitter. His Twitter is obviously registered under the brand name of Twitter. So it depends on what business you're basically going for. PayPal and Paytm, there was a case. Do you think PayPal and Paytm both have the same prefix? They can be confusing. Another point. Yeah, the PhonePe case, the Delhi High Court ruled that it's not deceptively similar. So in that case, I think the same principle will apply to PayPal. If PayPal and Paytm, both of them go to court, in spite of having the same prefix, they are not really deceptively similar. You know, the two are different. Another point is some customers know about brands. They have some consciousness about brands. Now, suppose you leave it completely to AI to, do your shopping. For example, Alexa. If Alexa is doing your shopping, is it possible that Alexa has imperfect recollection, which a common man has? A common man can differentiate between two brands and say buy a different brand. For example, somebody prefers Coke over Pepsi. It can be just a personal preference that somebody prefers Coke and somebody prefers Pepsi. Now, is it possible for artificial intelligence to know what the preference is and predict that for that person? So what about predictability? A lot of brands, at least in case of trademark law, depend on predictability. Now, in that case, what is the deal with AI? Can AI be relied upon for predictability? It can suggest options, but at the end of the day, brand consciousness is at the end of the day is an emotional thing. Somebody might emotionally prefer one brand over another. In that case, can artificial intelligence, it's a thinking machine, but can it really understand somebody's preference and buy the same thing? And if it can, then what is that for the consciousness of brands? It lacks predictability, that's true. So in that case, whenever brands target consumers to advertising. And when it comes to online process, sometimes, brands also enter into a bidding process. They buy certain words and they use those words, on Meta, on Facebook, on Instagram to basically bombard potential consumers. Yeah, they are collecting users' data. In that case, can artificial intelligence also basically get into this process and show you or bombard you with ads which they think you might be interested in? Because if they can do it, then for the companies, whenever they are advertising, they not only have to target the actual consumers, they also have to target the artificial intelligence of those consumers, because they are actually doing it, Vishwajit, with artificial intelligence. They are not doing it without AI. Meta, whenever you go and search for something, the next time you open Facebook or Instagram, you'll see products relating to your search suddenly flooding your Facebook page or your Instagram page. It's AI which is doing it. It's a targeted ad, and this ad is not actually a person who's targeting you with that product. It's actually artificial intelligence who's doing it. So basically, in a way, they are bidding, they are advertising. They are buying certain search terms and bombarding you with it, knowing that, you are probably interested in it. They have your data for the last 5-7 years. That's why they are giving you search. Anything you search, you'll often see products relating to that search. You might not even be interested on it. Sometimes you don't even have to search. Suddenly I sometimes find it very creepy. If you have a conversation with somebody about something, suddenly the next time you open a social media site, you will find ads related to that conversation you have probably had. It's basically AI which is doing it. It's not an actual person who was eavesdropping on your conversation. AI will target your conversation and basically bombard you with ads or products relating to that, thinking you are knowing it. In that case, I mean, this is in a way infringement. It's brand infringement. They are basically showing you brands which you're not interested in, or they're showing you counterfeit products. You probably are not even remotely interested in that. So in that case, how do you hold that person liable? Or because it's not a real person, it's actually AI which is doing it. Somebody has programmed AI to do it, but can you hold that person who has programmed AI to hold it? Yeah, exactly. This is what I was talking about. Whenever you even talk in person, they access your data and show ads. And trademark is all about advertisement, brands, etc. So in that case, basically, if someone is showing you ads, they are basically infringing your ad for this thing. Every ad, you can't basically show that, some ad without actually taking permission. Do you know about the concept of dilution? Dilution of trademark. Dilution of trademark is basically when you dilute a brand by using it for a product that brand is not related to. So dilution takes place when you undermine some product. So today, suppose you're using the Mercedes brand for a product which is not as good as Mercedes. So if you're using the Mercedes brand for undergarments, that is dilution of the mark. So now suppose somebody has made an Instagram reel and they show a brand in a negative light. Now, do you think that is a dilution of the mark? No, okay. Why do you think that is not a dilution of the mark? Yeah, it is tarnishing the value or brand name. It is dilution of the mark. If you create anything which is diluting the brand in any way, it is dilution of the mark. So what AI is doing also in a way, it's dilution. They are showing the marks in some other way by giving you targeted ads or by showing it in a light in which it's probably not even meant to be shown. Even the original owners of the brand probably don't even want the mark to be shown in such a light. Yet AI does that. So in a way, it's dilution of the mark. But as such, court has not yet come up with such a case. It's not yet been challenged before courts. But I mean, it's just a matter of time. In the next 2 or 3 years, it's definitely going to come up before courts. You can't ever show a mark in a light in which it's not supposed to be shown. Now, what Amazon does is, whenever it shows you one product, it also shows another product, its negative reviews, etc., through its targeted ads. Now, it's dilution in a way, but as long as nobody's challenging it at court, it will probably pass. Another very interesting concept is disparagement, if you have heard of disparagement. Shelja, am I running out of time?
Ma'am, if you want to take, you can have 5-10 minutes more. The discussion is interesting. So if you want to have it, you can have it 5-10 minutes.
I'll just take 5 minutes more. Okay. Yeah, so disparagement is basically showing somebody else's brand in a negative light. Now, some of you might remember there was an ad a few years back of Eveready versus Duracell. So there were two bunnies which were running. The Eveready bunny had a red colored jersey and the Duracell bunny had an orange jersey. Nowhere in the ad did you actually see the Duracell mark or the Eveready mark. They did not show that, you know, the red bunny is Eveready and the orange bunny is Duracell. But anybody who knows sees the ad will figure out that, you know, this is Duracell versus Eveready and the red bunny collapses and the orange bunny keeps running. So this is disparagement. You can't show somebody else in a bad light. You don't even necessarily have to show the mark. Even if you show something which is associated with the mark, that is enough to disparage someone. So in that case, the court said you have to take down this ad. You can't portray somebody else in a negative light. The same with Complan versus Horlicks. You'll see these ads coming up where mothers, you know, push aside bottles which look like Horlicks aside, and then they show you Complan makes you taller, sharper, stronger. So those are cases of where you're disparaging somebody else's brand. You can say you're the best. There's no problem in that, but you can't say somebody else is bad. And what AI does is precisely this. AI shows you products which apparently are good, and indirectly says that other products are bad. So this is completely illegal. It's not allowed under the Trademark Act, Section 29 and Section 30. But I mean, it's doing it. Now you can't hold anybody liable because it's not an actual person or a company. It's basically artificial intelligence. Yeah, Pepsodent and Colgate, Coke and Pepsi keep doing it all the time. Coke says Pepsi is bad, Pepsi says Coke is bad. And Dettol versus Lifebuoy. That's a famous case where, you know, they add a few drops of Dettol to the bucket of water. The bucket of water turns into a milky white color. They don't show the word Dettol anywhere, but that milky white color, you immediately know that, you know, that is Dettol. So they said you have to take down this ad. You can't allow it. Now, if AI is actually disparaging somebody else's brand, in that case, who do you hold responsible? AI does it all the time. AI says some brand is good and some brand is bad, which is not permissible under trademark law. It's perfectly okay to say you are the best, even if you are not the best, but you can't say somebody else is bad. Dabur Amla hair oil. Yeah, Savlon and Dettol. That was another famous case. where they said that if you apply Dettol, it hurts, whereas if you apply Savlon, it won't hurt. Maker and user and the brand whose help it does. You can probably hold the company who's commissioning the AI for disparagement. But at the end of the day, in these ads, it's not the company who's doing it. It's the AI who's doing it. Especially in case of all these online sites, they actually show you columns comparing different products, which is completely illegal because it's disparagement. They're saying one product is best and somebody else is bad. Yet these, these questions in the next 2 or 3 years will come up before courts. And if you are law students, when you become lawyers, I think you will get a chance to answer these queries in court before the judges and actually argue these cases. These will make up very interesting discussions. Okay, I think I've run out of time, so I will end here. I think the organizers have my email address. So if any of you want to have any questions or if you want to discuss anything, you're free to email me. Okay. Yes.
Thank you, Ruchika ma'am. So there we had the third technical session on the very first day of this ongoing under Mule Prabha value addition course under the UGC mandate, navigating intellectual property rights and emerging strands under artificial intelligence. Ma'am, I must say, a very enlightening session, very contemporary and futuristic. Now learning the session, you have raised the interpretation and scope of trademark, simultaneously the interpretation and scope of artificial intelligence, and how the trademarks and in artificial intelligence converge. So many meaning and concepts and issues that they are there in the trademark legislation that we students and we teachers and lawyers learn. Infringement, dilution, disparagement, how they are now coming into the domain of artificial intelligence. And then we put it on the humans, but basically it is also the artificial intelligence. So where's the victim, who's the culprit, and all the legal and academic angles that are being, so it is very much futuristic. You have dealt with all the examples, which also have piqued more curiosity into artificial intelligence and intellectual property rights. And hopefully we are looking forward to have you again back on this platform. Thank you so much from us.
Thank you.
Richa ma'am, over to you.
Thank you. Yeah, thank you, Ruchika ma'am, for being here. And I also want to thank you on behalf of our faculty convener, Ms. Alaknanda.
I know. So we have interacted.
Okay. Thank you so much, ma'am. As Shelja ma'am said, that the session had been very insightful, and we look forward to invite you again and to have another fruitful discussion with you on the topic.
Okay. Thank you.
Thank you so much.
Thank you, Ruchika ma'am.
The participants, it is for your notice that the technical sessions for today are over. We would be having our technical sessions tomorrow from 10 o'clock. Please join the sessions in time. Your attendance would be in accordance to your presence in the technical sessions, the inaugural ceremony and the valedictory. Accordingly, it will be, your attendance would be calculated and you would be given your certificates. At the end of the session, a feedback form would be shared in the WhatsApp community group, and you are requested to fill that feedback form. Thank you. Have a good day. Thank you, Shelja ma'am, for the
Thank you all.
wonderful
Thanks to you,
moderation.
Richa ma'am. Without you, wouldn't have been possible. Thank you.
So we'll take the leave.
Hanji ma'am.
Okay.
Thank you, ma'am.
Thank you. There's one more thing, participants. You need not use any other link for any other days. The same link would be available. All you have to, as you have registered, so the link which was available to you after registration, the same link would be valid for all the other upcoming 5 days. Thank you. Have a good day.